Your Ladyship, we have filed an IM.
You have not given the slip to the court master.
Your Lordship,
2 जनवरी 2026 को इसलिए फिक्स की होंगी क्योंकि आप एब्सेंट होंगे या कोई
Your
कारण
Ladyship,
नहीं।
I simply apologize for the
It doesn't make any difference.
We have also filed an
Don't
IM.
waste our time. You wasted our time by not appearing, and now you are wasting our time by mentioning. So,
Your Ladyship, I apologize for the inconvenience.
it's okay. Nothing. Heaven is not going to fall.
Your Ladyship, this matter relates to compassionate appointment. He is in urgent need of money, Your Ladyship.
Then you should have been more vigilant.
Your Ladyship, I sincerely apologize.
Rejected.
From supplementary list of final disposal item 1 second appeal 219 of 2022.
One matter from the list, if I may mention.
Sorry?
One matter from the list, if I may mention. This is the IAM sexual harassment matter, contempt matter, serial number 38. It's listed at, just praying that it may be taken up any time.
It will be taken up. There is already a notice. You have not read the notice. Notice, है ना?
Yes.
Yes. What happened?
Serial number 1.
Serial number 1 has been called where?
Second appeal 219.
Yes.
So I'm
Yes. So, no further argument.
Yes.
Yes. What do you have to say on additional substantial question of law? Nothing more?
Whatever has been argued, Lord, he stated that is substantial part.
Call Mr. Randall. You will not understand. And where is the state respondent? Where is the respondent? बुला के लेके आइए, ठीक है? कल के बाद से तो पढ़ेंगे ये लग रहा है। होता है इसका?
Yes, please.
I want to hear more from him from additional substantial question.
He has instructed me that whatever argument has been advanced yesterday, that is substantial.
See, when it comes to substantial question of law, if there is any, the court will certainly frame it. Okay? इतना कैजुअली मत लिया करिए किसी चीज़ को. आपका एक क्वेश्चन ऑफ लॉ में डिसाइड हो जाने के बाद उसके बाद कुछ क्या ही बचेगा. Anyways, like क्या बोलना? Yes, tell us what more. Yes, you complete your argument. You complete your argument.
More or less, that has been completed.
Your argument is complete.
Only on that point,
So just let us see each one of the substantial question of law and then we'll see. You just summarize whatever you have said. So far as one is concerned, what do you have to say?
whether the first appellate court has wrongly reversed the judgment and decree passed by the trial court by making out a third case that Urbanama was not in terms of section 72 of Chotanagpur NCA. So on this point, my
No, that is, you are reading the substantial question of law incomplete. Yesterday also you did not have the complete print. Today also you don't have it. When you do not know what is the substantial question of law, what argument will you advance? Read the substantial question of law?
Whether the first appellate court has wrongly reversed the judgment and decree passed by the trial court by making out third case that Arpanama were not in terms of section 72 of
This is
Chudana.
not the substantial question of law.
First is that whether the first appellate court has wrongly reversed the judgment and decree passed by the trial court by making out the third case that first, the person who had executed Arpanama only had a fractional interest upon the suit property. Second, the Sruti Kriti Devya had other heirs and original plaintiff. So, plaintiff was not the alone nominated Sevaya. And the third is that Arpanama was not in term of section 72 of the Chhodana Ordinance.
We get that so
So-
far as section 72 is concerned, that was never the plea raised. Okay, section 72 plea was not raised. What about 1 and 2?
One is that, let's say, the person who had executed Arpanama had only fractional interest upon the suit property. However,
Where is that finding? Where is that finding of the learned appellate court? Show me that paragraph.
paragraph is
Page number.
page number is, let's say, 36. Internal page 26. May I read?
Appellate court has only 32 paragraphs, 32 pages.
Internal page number 26 of 32.
26.
Yes.
It's 26. Read that finding.
Yes. I further find that M form has been brought on the record on behalf of the plaintiff respondent that has been marked as Exhibit 4, but no
Just
discipline.
a minute, let me just at the top. Okay. Read it from in this connection and this judgment.
In this connection, the Honorable Jharkhand High Court Ranchi in first appeal number 43 of 2012 MS Sahara India Commercial Corporation Limited versus Uday Shankar Paul and others
That judgment has been now set aside.
set aside.
Okay.
So the judgment which they are taking shelter of that has been set aside. So this may be
What is the case number?
case number is first appeal number 43 of 2012.
Case number of the Honorable Supreme Court. Case number of Honorable Supreme Court. I told you yesterday to give
Yes.
me the case number. Where is that case number?
Yes, case number.
SLP civil number.
It is civil number. Civil appeal number 6781.
Civil appeal number
6781.
6781.
Yes, that's 26782 of 2023.
Judgment dated.
Yes. Judgment dated is Chap, 26 4 2024.
24.
24, yes. 26 4 2024.
All right. Read further.
So, may I read further?
Yes, yes.
The plot that have been recorded as Bandh Jhari and Devasthan in the cadastral survey record of right 1928 are lands of the nature which vested in terms of section 4 of the BLR Act. Mere issuance of M forms with respect to such land cannot protect these lands from vesting. I further find that Form M has been brought on record on behalf of the plaintiff respondent and has been marked as Exhibit 4, but no description of suit plot, etc. has been mentioned in this Form M. I further find that it has been pleaded that Panchulal Sandhi was Khewatdar of Khewat number 7, but this Khewat is Ismal Khewat, meaning thereby Panchulal Sandhi was not the sole Khewatdar or proprietor, tenure holder, rather there were also other Khewatdar, which is also crystal clear from the Khatiyan of Khata number 55 of Moja Bakaspura, marked as Exhibit 3, and as such he has no right to solely execute the Arpanama, which has been marked as Exhibit 1. I further find that this Arpanama of dated 28/1/1923, and as per this Arpanama, Panchulal Sandhi executed the same in favor of Sri Lord Shiv Thakurji, wherein and whereunder he made himself Sevayat of the deity, and described that after his death by Kuntnath Dasandi, his nephew, that is Bhatija, would be Sevayat. I further find that Arpanama dated 17/8/1954, Exhibit 1 by A, has also been brought on record on behalf of the plaintiff respondent, which has been executed by Vaikuntnath Dasandi, wherein and whereunder he had appointed Shruti Kriti Devi as Sevayat of deity. But in this Arpanama, description of suit property has not been mentioned. I further find that neither khata number nor plot number has been shown in this Arpanama. I further find that certified copy of order dated 25/4/2005 passed in miscellaneous appeal number 9 of 2004 Exhibit 6 has also been brought on record on behalf of plaintiff respondent, and from perusal of the same I find that the plaintiff had filed application for settlement of the tank, and after dismissal of appeal, instead of filing revision before the commissioner, he filed title suit number 114 of 2000.
So which portion of this finding is contrary to the plea?
Ladyship, here the judgment reads that the Khewat is Ismal Khewat. However, the Panchulal Sandhi who made the Arpanama, thereafter his successor also made Arpanama with regard to the same property, and he appointed Shruti Kirti Devi Sevayat.
So that is okay. But if the document is showing that it is Ismal Khewat, the court will not look into that. That the property is, you are seeking your title, right? If the document itself is showing that it is Ismal Khewat, means in joint name, the court is precluded from looking at that.
No, court is not precluded, Ladyship, but however, the court should have taken notice that both of the shareholders have given their Arpanama.
Who were the two shareholders?
Panchulal Sandhi and his nephew, Ladyship.
No, nephew was the successor because he appointed his nephew as his successor, Sevai.
Sevai.
Yes.
And his successor also appointed Shruti Kriti Devya as.
So that is a separate thing. When it talks about Ismal Khewat, apart from this Panchulal Dasandi, who was another person? Nephew is deriving through him only. Who is the other one? The finding that it is Ismal Khewat
Yes.
as recorded, is it an incorrect finding?
In this regard, it is not incorrect.
It is not incorrect.
Not
So this finding is
How-
correct.
This finding is correct.
Okay.
However, if Ladyship allows me, then
So how is it perverse that the persons who had executed Arpanama only had fractional interest upon the suit property? This is not perverse. The moment you admit that it is Ismal Khewat,
Ismal.
it cannot be said.
my
Yes. Was the nephew joint holder of this kevat? No.
no.
This is not a perverse finding. We cannot say that this is perverse. By making out a third case, the court will look into the documents.
Ladies, only one attention I would like to draw. Ladies. Form M, ladies. Form M.
Form M, who exhibited Form M?
Form M is exhibit 4, ladies.
Who exhibit 4? So it was the plaintiff's
Yes.
document, right? You relied upon Form M.
Yes.
Okay, now this part is over now. So you are talking about Form M. What do you want to say about Form M?
In Form M, only top of the Form M reads that Darmiyani Hakdar ka naam. Here we will find that Sri Shivji Thakur Sevait Srimati Shruti Kriti Devi Swami Sri Chandri Prasad Sharma. That is in the M form itself. The name of the mother of the plaintiff has been mentioned as a Sevayat of that land, and that has been
What is Form M? What is Form M?
Form M is the document given by the state to the real intermediary litigation. Form K has been is filed by the intermediary, and then after
So Form M is a document of the state.
For under Form M, here repeatable ground rent is assessed, but it doesn't appear. This is 3K, 3 kha, meaning by that it may be returned, which my learned friend is showing.
You see, any question of law which is if this is not relatable to question of law, we will not hear it. Now, number one is over, that you cannot say that you had full interest, because this part the court will certainly see. Now, Shruti Kirti Devi had other hearers, and the original plaintiff was not the alone nominated Sevai. Right? Where is this finding? Because this part he did not argue yesterday. Where is this finding which you are telling me?
yes, this funding is, let's say, that has come. The argument was advanced that suit is bad for non-joinder of the necessary party, as mother of the plaintiff had 4 sons, one son.
Where are you reading?
It is let us say running page number 28 out of 32 years.
28.
In fact, it starts from page number 27. May I read?
Page 27.
Last 3 lines. 2 lines from the last line.
Yes, please.
I further find that in Arpanama dated so and so that it was provided that Srimati Chuna Devya would be the Sevayat, and after her death Shruti Kirti Devya would be Sevayat, and after death of her sons would be Sevayat, but this has not been mentioned in the plaint of the plaintiff. I further find that it is also the fact that one petition under Order 1 Rule 10 Sub Rule 2 CPC was filed by one of the sons of said Shruti Kirti Devya, namely Rishikesh Sharma, claiming himself to be Sevayat and prayed for making him party. It shows that the present respondent is not the alone heir of Sevayat Shruti Kirti Devya. The said Shruti Kirti Devya died leaving behind his 4 sons, namely Naveen Chandra Sharma, Rishikesh Sharma, the petitioner of the said petition, Akhileshwar Prasad Sharma, Sarveshwar Prasad Sharma, the respondent number 1. The eldest son of Shruti Kirti Devya, Naveen Chandra Sharma, also died leaving behind his two sons, namely Gopal Shankar and Amitabh Shankar. And Shruti Kirti Devya had also two daughters, namely Saroj Devi and Amboj Devi. Thus, there are several heirs of the said Shruti Kirti Devya, but it is not pleaded that amongst the heirs, the respondent number 1 is alone nominated Sevayat, and thus he has no locus standi to file the suit alone, or the suit is bad for non-joinder of parties, and when there is differences amongst the heirs of any trust or Sevayat, Section 5 of the Religious Endowment Act 1863 would apply. It was the duty of the respondent plaintiff to plead about his appointment as Sevayat amongst the other heirs of said Shruti Kirti Devya, but it is lacking in the pleadings. In this connection, I find that Honorable Supreme Court has also observed in the judgment reported in AIR 1979, Supreme SC 1682, that Sevayatship being property devolves like any other species of heritable property, which ladyship asked yesterday to my senior. I further find that during the recent revisional survey, the tank is recorded under RS Khata number 91 in the name of Annabad Bihar Sarkar, and is finally published on 21st February 1991, which is crystal clear from the Exhibit 3, and the same is conclusive proof of possession as per Section 84, subsection 3 of CNTF, and as per this section, every entry in record of rights to publish shall be evidence of the matter referred to in such entry, and shall be presumed to be correct until it is proved by evidence to be incorrect. But neither the sole respondent nor any Sevayat filed any objection against the entry either under Section 87 or under Section 89 of CNT Act, and it is held by the Honorable Jharkhand High Court in the judgment reported in JLJR 2003, volume 2708, that recording is final and conclusive proof of possession. I further find that tank is in question are being auctioned, which is also crystal clear from Exhibit C series, and the respondent plaintiff never made any objection to this auction prior to filing the instant title suit number 114 of 2005. Neither the plaintiff nor any other legal heirs and successor of tenure holders of Khewat number 7 owned the tank and its I in question. Rather, they prayed before the revenue authorities for settlement of the same, which itself defeated the claim of the plaintiff respondent. Further, leadership, apart from aforesaid fact, I also find that in the pleaded document, that is Arpan Namas dated so and so and 1954, the details of the land has not been mentioned, and these documents are related only with management of the said Devalaya Shiv Thakur, and in the document dated 17/1/1923, Panchulal Sandhi executed Arpanama, as this Arpanama was executed prior to preparation of cadastral survey record of right, and there is mentioning of khata and plot. It is the matter of judicial notice that after preparation of cadastral survey in the year 1925, the plot number and khatyans came to the picture, and in the Arpanama dated 17/1/1923, there are boundaries given, but no other details have been mentioned in it. This document also shows that there are other co-sharers, as though this Arpanama said Panchulal Gasambi made this document only to the extent of his 3 Anna shares.
So the court is proceeding under by taking cue from the document in favor of Shruti Kirti Devya, that it was mentioned therein that after her death, her sons would be the, there is a plural term used, and then the court is referring to the various persons who had come before the court, including one intervener application. His intervention was rejected.
With regard, leadership, no filing has been recorded.
So somebody had appeared,
Yes.
and then the court says that he was not the sole, he could not have been the sole survivor. The court is referring to your document only. So, how is it perverse? Whenever you are seeking your title, the will see, look at all your documents, irrespective of any objection made from the respondent. The court will have to look at your documents. If your documents are self-speaking, then under such circumstances, suppose the defendants do not appear, the proceeding is ex parte. Will you get the decree by default? No. You have to make out your own case. The court has recorded that you could not have been the sole Sevayat after death of Shruti Kirti Tekia on the basis of your own documents. Right? Yes, so far as 72 is concerned, there is no pleading that there was no prior permission is required. No? Under
Prior.
72?
Since 1947, right to know, right to that it was not required. 1947, right to 1947.
Yes. So that particular part we can say that nobody pleaded and there was no scope for going into that issue. But these two parts, that Arpanama, you had only fractional.
However, ladies, regarding petition under Rule 1, Order 10, that is Order 1, Rule 10, we have here the court has also not recorded that whether that has been opposed by the plaintiff.
We do not know. आपको पता होना चाहिए ना आपका petition का क्या हुआ.
That was not my petition.
Maybe or not your petition, but it's a part of the record. So, you have not seen the record. You are not aware.
The finding has not been recorded.
There are two things. You forget about that order 1 rule 10. But certainly, in your document itself, plural was used.
But it is not a Sevayatship is a voluntary service relationship. It is not binding that.
Therefore, I wanted to ask you yesterday, is it heritable? Shevayat right, is it heritable?
With regard to that relationship, the finding has been given that the Sevayatship being property devolves like any other species of heritable property. That has been recorded. But if
If the
someone,
document itself is saying that after death of this lady, her sons would continue, so there has to be more than one.
but if willingly or reluctantly they have rejected their right and they have not come forward, they accept the plaintiff himself, then this should have been recorded by the first applicant also.
What else? एक second. With respect to the first substantial question of law, the learned counsel for the appellant has referred to the finding recorded by the learned first appellate court at internal page 26 and has submitted that the judgment which has been relied upon by the first appellate court passed in first appeal number 43 of 2012 has been set aside by the Honorable Supreme Court in civil appeal number 6781 of 81-82 of 2023, and the matter has been remanded to this court for fresh consideration. He submits that in the said case, it was held that mere issuance of Form N with respect to any land cannot protect the land from vesting. The learned counsel has also submitted that the learned court has recorded that the Khewat was Ismail Khewat, E-J-M-A-L, Khewat, meaning thereby Panju Lal Dasondi was not the sole Khewatdar or proprietor tenure holder. Rather, there were other Khewatdars also. and therefore he did not have exclusive right to execute Arpannama with respect to the property, to which the learned counsel has submitted that there was another Arpannama executed by the co-sharer of the property. Namely, क्या नाम था co-sharer का?
Bakuntnath.
Bakuntnath
The song.
Daswani.
But treaty is that after the death of original Panchula the song.
नहीं not ट्रायल कोर्ट के जजमेंट में नहीं ट्रायल कोर्ट के जजमेंट में है अनदर खेवट का
Bakuntnath the song.
Bakuntnath Daswani.
Bakuntnath.
The learned counsel has further submitted that Shruti Kirti Divya, that further finding of the learned appellate court that Shruti Kirti Divya had other legal years and the original plaintiff was not the alone nominated Shivayat. He submits that the learned court has recorded findings with regard to other legal years of Shruti Kirti Divya and has recorded that there were 4 sons, that she had 4 sons. And at the same time, the court has recorded that it was not pleaded that amongst the years, the plaintiff was the sole nominated Shivayat and was of the view that the plaintiff did not have the locus standi to file the suit. The learned counsel has submitted that the plaintiff was the learned counsel has submitted that it was nobody's case. The learned counsel for the appellant has submitted that the plaintiff being one of the son of Shiva Kirti Devi, Shruti Kirti Devi, certainly had the locus to file the case.
If leadership only allows me, I would read one paragraph from the exhibit on by Bill.
Exhibit
Yes.
for what?
So that it will be clear that the Arpannama was executed by both of those who were sharing his mal.
The original Arpannama.
Arpannama dated 4/5/1946, which was executed one by Bill.
No, that is not the question of law. We will not enter into that. Otherwise, there are so many Bangla documents we do not know.
No, it is in Hindi. Not one. is in
Exhibit number
1 by
1 by
B.
पढ़िए जरा देखिए
He translated.
ट्रांसलेटेड कॉपी तो हमें नहीं पढ़ी। आप अपने पास रखिए ट्रांसलेटेड कॉपी। इट इज नॉट अ पार्ट ऑफ द record also.
It is translated copy of Bangla.
That is part of your record, not a part of Group's record. You do not know. What translation have you done? The Learned Council has further submitted that the state never raised any objection with respect to Section 72 of Chotanagpur Tenancy Act, and therefore there was no occasion for the Learned First Appellate Court to enter into such an issue. He submits that the First Appellate Court has wrongly reversed the judgment and decree and made out a case which was never the case of the parties, and therefore the first substantial question of law is fit to be answered in favor of the appellants and against the respondent. ठीक है, second बताइए.
Second is whether the lower appellate court was right in holding that Exhibit 3 was the conclusive proof of possession as per Section 84 of Section 3 of Chotanagpur Tenancy.
With respect to second substantial question of law, the Learned Council for the appellant has submitted that as per Section 84 within bracket 3, the Exhibit 3 at best would have a presumptive value, and the same cannot be said to be conclusive proof of possession. However, he has submitted that the presumption was required to be rebutted through evidence. कोई ऐसा evidence है?
Evidence, let's say, furthering substantial question 3, which
Okay, just a moment. That is all. Number 3.
whether the learned lower appellate court was right in discarding Exhibit 1 by B and 1 by C, which I was intended to read there. And on the ground that they were beyond pleadings in view of the provisions contained in Order 6, Rule 2, Sub-Rule 1 of the Code of Civil Procedure.
What is order
However,
6?
that is a translated copy of Bangla Appannam.
Order 6 rule 2. It is beyond the pleadings. No such reference was made. Is it beyond the pleadings? Exhibit 1 by B and 1 by C
1
were
by C.
exhibited by whom? By the plaintiff.
Plenty.
But no reference of this particular document was there in your plaint, correct?
Initially, it was not there. No.
Then you amended your plaint.
Though it has been marked Exhibit 1 by B and 1 by C.
Marking से क्या होगा? With respect to substantial question number 3, the Learned Counsel for the appellant has submitted that merely because there was no reference of Exhibit 1 by B and 1 by C in the plaint, the same cannot be termed as beyond pleadings, inasmuch as in view of Order 6, Rule 2, within bracket 1 CPC, the plaintiff is supposed to plead and state material facts and not evidence. And and therefore the finding of the learned first appellate court in rejecting exhibit 1 by B and 1 by C on the ground that they were beyond pleadings is not in accordance.
Yes.
और ये वाला बताइए. Roman 4 तो आपने you have given up
Yes.
yesterday. During the course of argument, the learned counsel for the appellant has submitted that the substantial question of law number 4 does not arise for consideration by this court, to which the learned counsel for the state has also no objection, and therefore this substantial question of law is not pressed during the course of hearing. Correct?
Yes.
Next, then.
Whether the appellate court was right in reversing the judgment and decree passed by the trial court on the ground that the deity was not made party.
Yes.
Yes. With this, with regard to this substantial question, let us for my submission is that deity is represented by Sevaisi, and when he is the party, that is, he is managing the estate of deity, then deity is not necessary to make party.
With respect to substantial question of law number 5, the learned counsel for the appellant has submitted that the description of the plaintiff itself indicated that the plaintiff was representing the deity. ये लिखे हैं, being the Sevaith.
तो अपना ही नाम से थ्रू गेटिव थ्रू
आपका ऑब्जेक्शन होगा इसके बियॉन्ड वो क्या ही बहस करेंगे.
हाँ हाँ ठीक एज सेवाइट लिखा हुआ है
As Sevaith लिखा है.
एज सेवाइट बट डेटी का रेफरेंस नहीं है
हाँ.
डेटी
But as Sevaith, and therefore, and the details of the deity has been mentioned in the plate, and therefore, for all practical purposes, the plaintiff was representing the deity. Therefore, this substantial question of law is also to be answered in favor of that. That's it.
Yes.
However, during the course of hearing, it is not in dispute that both the courts have given concurrent finding that the property involved in this case vested with the state by virtue of Bihar Land Reforms Act,
Yes.
and no substantial.
being tank on not used for agriculture purpose इनका केस ये नहीं है कहीं agriculture purpose है या pertaining to agriculture ठीक है
ना हम
हाँ नहीं हाँ yes.
अब बताइए आपको क्या.
वही जो सेक्शन 4 of the Bihar Land Reforms Act is the land vested into the state and the land was and the suit property is the related to pond not and there is no reference of any agriculture purpose so it invests in the state
इससे ये तो बहस ही नहीं हो रहा है क्योंकि वो सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं है.
घंटा कोई कर सकता
आपने तो उस दिन वो
हाँ जो
जजमेंट
लावण्य देवी हाँ
and you say that on the basis of that judgment the
then there is
issue
no
is settled by the Supreme.
then there is no substantial question of law.
There is no substantial question. वो तो हम कल लिखा है.
हाँ वो तो लिखा है
The learned counsel for the respondent has submitted that there are concurrent findings recorded by both the courts that the suit land has, which was in the form of pond and admittedly not used for any agricultural purpose, had vested in the state of Bihar and in the state under Bihar Land Reforms Act, and the issue is covered by the judgment passed by the Honorable Supreme Court in the case of Lavanya, and therefore no such substantial question of law arises in this case. And so far as the बाकी substantial question of law के बारे में आपको क्या बोलना है?
बाकी substantial question one कोई third के the learned appellate court has not made out anything.
The learned counsel for the respondent has submitted that the learned appellate court has scrutinized the materials on record produced by the plaintiff and
has not made out a third case.
has not made out a third case. The plaintiff has to make out a case on the basis of pleadings and materials placed on record. 72 के बारे में क्या बोलना है?
72 का
वैसा कोई pleading नहीं.
pleading.
However, during the course of hearing, the learned counsel for the state has submitted that no plea with respect to Section 72 of the Chotanagpur Tenancy Act was taken in the written statement, but the same was essentially a question of law which could be taken care of by the learned first appellate court. यही तो बोलेंगे. इसके beyond तो कुछ नहीं.
But the learned first appellate court had taken it as that there was Samarpanama. That's why the learned appellate court had taken it that it is surrender. Otherwise, there would have no question before the first appellate.
The learned counsel has also submitted that the learned appellate court, first appellate court has taken the documents produced by the plaintiff as surrender
हाँ sir.
instead of taking the same as
इसमें तो समर्पण
arpanama.
अर्पण
Arpanama. That is gift to the deity.
हाँ ये अर्पण
And this one, ये तो conclusive
हाँ
नहीं होता है ना?
हाँ conclusive
With respect to substantial question number 2, the
Rebuttable तो
learned
है,
counsel
rebuttable.
for the respondents has submitted that as per section 84 within bracket 3, the entry in record of right is not the conclusive proof,
rebuttable.
has a presumptive value,
हाँ of
but
correctness. Presumptive value of its correctness.
but it was for the plaintiff to produce evidence to rebut the same, which has not been done by the plaintiff. बस आगे exhibit 1 by B and 1 by C.
इसमें तो pleading का भी part नहीं था.
The learned counsel for the state has submitted that with respect to exhibit 1 by B and 1 by C, there was no foundational pleading
हाँ no reference about.
and no foundational pleading to support the pleading through this exhibits, and therefore the learned first appellate court has rightly discarded exhibit 1 by B and 1 by C. The learned, with respect to substantial question number 5, the learned counsel for the respondent has submitted that the appellate court was the plaintiff only described himself as Shivayat, and deity was a necessary party. That is all. आज है Friday ना? Just a moment. I'll just post it for judgment on that. Arguments concluded, post for judgment on नाइन्थ ऑफ जून. आपका ये एडिशनल सब्सटेंशियल क्वेश्चन ऑफ नॉलेज है. I'll pass it on to you. Section 4. But in appropriate case, I will pay. Not in this case. This case no issue. कल इसका डिक्टेशन पॉइंट वो कुछ नहीं है. इसको कवर कंप्लीट करके दे देंगे. इसको कंप्लीट करना है. इसको कवर
For hearing under order 41/11 item 2, second April 14 of 2023.
yes.
Leadership in this matter was being over actually. Yesterday night I submitted an adjournment notice.
Who has circulated the new notice?
On behalf of the billion company.
When?
Yesterday, around
कल तो नहीं आया? अभी लेट नाइट में कितना बजे भेजा? ऐसा है ना 5 बजे के बाद आप कुछ भेज नहीं सकते हम लोग यहाँ पे माय ऑफिस इज नॉट अवेलेबल टू यू राउंड द क्लॉक देयर इज नो ये थोड़ी है आपको 2 बजे मेल कर दी हो गया एडजमेंट नोटिस
sincere apologies for that issue, but even also Mr. Gaurav said was legal issue, but there is some medical emergency. His family, his wife is admitted in hospital.
medical emergency what is it what is this matter about बताइए क्या है
Declaration of right title interest over this
मुस्लिम लॉ हिंदू लॉ what is it
Muslim.
this is second appeal concurrent findings delay condoned
Delay was controlled, so notices were issued.
nobody had entered appearance still nobody has entered appearance
Yet, no name appears in.
क्या पता इधर उधर घूम रहे होंगे क्योंकि notice has been served upon
This was
देखिए essay number 40 of 2023 the learned counsel for the applicant seeks adjournment an advance notice seeking adjournment has been circulated till now nobody has entered appearance on behalf of the respondent though notice was issued for the purposes of in the limitation matter only. This appeal is yet to be heard. The order 41 will be there. कब रख दे बताइए
next week, Thursday, yes.
post on next Thursday in the supplementary business. जैसे अभी बन जाता है सब्सटेंशियल आज नहीं बनेगा वैसे है इसमें matters the matter relates to interpretation of the document itself. Let us see.
From daily list for final disposal item 1, WPC 1873 of 2018.
Pass it. Next. 2 मिनट के लिए ना दो आपको ऑर्डर भी टिकट पर
For orders be defect item 3, first appeal 153 of 2018.
what are the defects to be cured?
There is a limitation of 27 days.
27 days.
Days, it may be controlled.
That is the only defect.
No, one more defect is there. Court is already filed.
Yes.
As per the case 31 is quite eligible. For that, type copy was required.
Court fees you have filed.
Court fees I have filed for rupees 12,002 rupees.
Which all are the defects to be cured?
Not only one type copy they are seeking. So for that purpose, either give me 1 week time, or it's quite legible that it's page 31.
CC of the award is handwritten.
That is the only defect.
Details of respond number 1 may be given and verified.
So that has already been removed.
When did you do?
That has been corrected. Actually, previously it was the state of Jharkhand that has been deleted. Only the Deputy Commissioner Ramgarh is the party. As per the award.
Deputy Commissioner. There are two opposite parties.
One
The
deputy is
deputy. So you have already removed.
that has been removed.
And the handwritten is CC of the award.
At page 31. Either I may be permitted 1 week time to file type of, or it's legible.
FA number 153 of 2018. Counsel for the applicant has submitted that all the defects have been removed excepting
Limitation.
defect number 3. Wherein the typed copy of the award is to be filed. He submits that the award is fairly legible, though some portions are handwritten. Even the handwritten portion is legible. Considering the submissions and having gone through the award, the defect in connection with typed copy of the award is ignored for the present. बस हो गया? IA number
I remember 2487 for limitation 27
2487
of 22.
of 22 has been filed seeking condonation of delay of
27 days.
47 days.
27 days.
27 days. Any objection? The counsel for the respondents has no serious objection with regard to prayer for condonation of delay. Having gone through the interlocutory application and being satisfied with the portion, the delay in filing the appeal is hereby concluded. आगे बताइए.
Kindly be admitted. Other cases are turned
When?
22nd of May.
20
2nd of
substitution
May.
भी है. There is one substitution
Substitution
also.
already we have filed the wakalatnama. Substitution is also there.
Allowed
Uh,
or pending.
may be allowed.
Substitution किसका?
Sodna Vedia, the sole appellant has died on 6/3/2020.
You have filed your वकालतनामा.
Wakalatnama is also.
4478 तो अलाउ करना पड़ेगा ना. खुद ही नहीं पता होता है क्या करना. 44 I8 वाला लिमिटेशन का नंबर है 2487 of 22. And this is 4478. When did she die?
On 6/3/2020.
Prior to the degree.
No, after filing of this appeal. Appeal has
During
been
the
filed in the
pendency
year
of this
2000.
appeal.
Appeal has been filed in the year 2018.
Any objection? Who are the legal representatives?
Son is
Where is it mentioned?
paragraph
Appealant number 1.
1. Kodana.
Motilal Bedia. His wakalatnama has been filed along with the interlocutory application. This IA number 4478 of 2022. The learned counsel for the appellant has submitted that the appellant number 1 namely Sudna Bedia expired on 6/3/2020. And due to COVID-19 pandemic and on account of related reasons, immediate steps could not be taken. However, petition for substitution has been filed by the affidavit dated 21/3/22. He submits that she is to be substituted by her only son, namely Motilal Bedia. His wakalatnama has also been filed along with the interlocutory application. Counsel for the respondents has no serious objection to the substitution. However, they have submitted that the substitution may be allowed only for the purposes of pursuing the appeal and no more. Correct? क्योंकि बेटियां भी हो सकती है ना, we do not know. नहीं पता.
They are scheduled caste, scheduled tribe.
So?
But right of the doctor is not. Only we used to file on that side.
It's too loud a word. That is why, only for this case. After hearing the counsel for the parties and considering the facts and circumstances of this case, IA number 4478 of 2022 is hereby allowed. The counsel for the appellant is directed to delete the name of appellant number 1 from the cause title and insert the name of my son, namely Motilal Bedia, whose details have been mentioned in the wakalatnama filed along with the interlocutory application. This order has been passed only for the purposes of this case, and the substituted and the legal representative of deceased only for the purposes of this case. That's all. And this court in this order has not decided the succession of the deceased appellant.
They are guided by the customary law.
वो आप जानेंगे, हम नहीं जानेंगे. पास हो गया? इसमें डेट कब देना है?
2nd of May.
अब एडमिट कर ले इसको.
Admit कर ले.
उसमें रिकॉर्ड आ गया.
हाँ, the order has also been filed passed now in batch cases.
That's it. 2nd May का रिकॉर्ड आ गया है. At this, the counsel for the appellant has submitted that the case may be formally admitted and posted on 2nd of May, as other cases arising out of the same land acquisition proceedings are listed on that day. Counsel for the state has no objection. Admit, post on 2nd of May. अब आप फाइनल डिस्पोजल में आ रहे हैं, कितने मैटर्स हैं?
केस फाइनल डिस्पोजल 4-5 केस
4-5 केस है, ज़्यादा तो है नहीं.
Item 4, first appeal 173 of 2018.
सेम कहानी.
Same limitation is 27 days.
How many days?
And 27 days.
अच्छा.
Substitution is 3 sons have been substituted. Wakalatnama is already filed.
वकालतनामा फाइल कर दी.
File period court fees have also been deposited. Type copy is also there. Only that one defect is there. The name I mentioned that late Tura Munda, father of 427, but it should be as per the award. It should be late Tura only. So either I may be permitted to correct or add the alias name. because Tura Munda and Tura are the same person. As per
ऐसे
what-
नहीं आपको एफिडेविट फाइल करना पड़ेगा ऐसे एलियस नेम हम लोग नहीं डाल सकते
नहीं तो only I correct the Tura.
FA number 173 of 2018 counsel for the applicant seeks judgment बिना एफिडेविट के एलियस नेम हम लोग ऐसे नहीं
ठीक है
डालते
करेक्ट है.
एफिडेविट ऐसे नहीं हो सकता नेक्स्ट वीक मंडे रख दीजिए मंडे रख दें हो जाएगा एफिडेविट आपका
नहीं नहीं
Wednesday.
They have I have to call it.
वेडनेसडे पाचू
Also case item 1 WPC 1873 of 2018 belongs to the
You was going for second of January, Dr. Singh is me not to reserve.
second of May is Friday is और ऐसे time नहीं मांगते।
Friday, every Friday. Therefore, he took his time on Friday. And Thursday, I asked him, he is in a partner before he spoke me.
We need 2 consecutive days. We need 2 consecutive days. ऐसे आज सुनने के बाद 1 महीना बाद हम नहीं ऐसे नहीं कर सकते।
I know. This has to go on continuously. Else there is no use.
10:30. You choose your day. ऐसा नहीं होगा ऐसा पार्ट में नहीं सुनना
हम first और second ही बोल सकते हैं. First, I have spoken to Mr. Krishnan Gopal. He will come. Second, Dr. Singh will conclude. That is all I have spoken.
1 तो ठीक है 1 तारीख को शुरू करते हैं।
That is one option. Next is that file an application in IE. Kindly have a look. This will throw some light on the matter because what we are facing is because of that. That now the government of India also agrees that we have a genuine difficulty. It is now reconsidering the entire.
You see, if you have a genuine difficulty, the respondents also acknowledge that you have a genuine
Yes.
difficulty. You withdraw this case, pursue it.
No, the law is changing. They are changing the law. They are saying that there was no law, there is no uniform policy regarding penal compensatory afforestation. We are reconsidering it. And penal CA was the problem for 6 times.
So therefore, there will be no adverse order against you. You withdraw this case. Whenever the new policy comes, you pursue.
I am pursuing my remedy. Therefore, that is the IE. Kindly have a
And
look at
therefore,
my-
you withdraw this case.
IE is for a direction.
No, what direction? We are not going to pass
That
it.
kindly just expedite the forest clearance matter.
ये यहाँ से ये सब direction है.
Because ये तो we are only trying to resolve the issue without getting into the nitty-gritty. That's it. Your Lordship's endeavour has always been, and it is still. We all know that this plant is running because we are before the court, and the governments are also. They are not opposed to running of the plant. We are not violating any law. We are not violating.
Violating. You see, these environmental issues are basically public interest matters.
But there is
Right,
no.
because the respondents are not objecting to your adjournments. We will not
The emissions are within range. The only dispute, this Genesis is a forest land. Now we have, without prejudice, applied. We were granted. Your Lordship, we were granted. They imposed a condition of 1:6 times CA land, penal CA land. We got 1:2, 1:3 minutes almost. Now they themselves, Government of India, having realized, not in my case, that this is creating a problem. There is no uniform policy. Is reconsidering the entire issue. I'm just bringing to your Lordship's notice that this may be just throwing light that we were not trying to evade any condition which the government of India. If the state of Jharkhand has been very cooperative, they have also been doing everything. This is the only greenfield project which has come
You
up.
see, once at the time of disposal of the case, we can simply say that there is a policy and they are in the process of taking a decision over the policy, and then you can you can pursue your matter before them as per the new policy. In anticipation of policy, this case will not remain pending.
My case relates to the revocation of the first DC. My case does not involve it.
So therefore, let's hear it on this. We are not going to adjourn this matter. Now there are more judgments which are coming up from government, more stricter than what was the regime earlier. New directions have also come. I think that we have crossed a particular line on this country.
Then I have given the most honest thing that first and second, but second Dr. Singh, if you know, it is only will be in part, some by Mr. Vinupal and some by
That's not a problem. Anybody can argue. You can also have it part.
No, that to me is not the So I was only playing, see if your Lordship can accommodate some second minute, then it can.
Second में तो खत्म नहीं होगा ना.
नहीं होगा.
हाँ,
ये
day
भी
time.
second में भी वो कह रहे
May
second.
day is the best day for this kind of a case. days.
May Day is also a signal for trouble. So that's the in aviation and
What
in
trouble?
no aviation and
Red flag.
it's signal. May Day is
No,
like
no,
I'm
no.
gonna crash. So
Mayday is also,
I don't want it on May Day. Right?
it's a red flag note. Mayday is also a red in color.
Let us decide this case. We just can't.
No, I understand, Nurse. This has to be decided. Can it? I just
And the space that was granted to you by Honorable Supreme Court was only for a limited period, for a limited purpose. And I think with the passage of time, that particular ventilation or that particular window has lost its efficacy.
only second members. Second. Let us keep it on second members. Piecemeal, whatever Dr. Singh
Second May will start, not first May. Not second.
वो फिर
कोई बात नहीं, उनको आने अच्छा है 2 दिन
नहीं वो तो ठीक है. First
ऑनलाइन करेंगे कि आगे
नहीं,
करेंगे?
Mr. Venugopal comes here physically on first if your lordships, and then he goes back and then joins Dr. Singh on second May virtually. So that's what.
That's not that. So he will be there. Let's do it. Let's do it. It's for pending here.
The pending is we also just trying to resolve the issue in a very amicable manner with the government of India and without violating any law. That's we also don't want to be seen as the violators of the law. We don't stand to gain anything.
An affidavit to the last week itself. So for the previous application on the basis of which one of the last adjournment was made, so that has not been exceeded by the Union of India. And the
Rejected.
No, not
direction
rejected.
has been issued.
Not exceeded means what?
You know, that has not been accepted. Can you see over the letter which I will find?
No,
But
we'll
they have
see,
not-
we'll see.
Actually, they have given a fresh presentation to the petitioners.
It
On
will go on.
1st of February.
It
And
will
to
go
which
on.
notice
There's no
they have not marked that in representation to us, the state government, for getting a report from us.
I'll tell you one thing. Right? They are happy. You are happy, both all of you, helping each other.
No, but that is
So
not
there
what
is
the
there is no
Union of India
purpose
says.
of keeping this matter pending. You just go and get it decided through whatever means you want. But this court will not be a party for your non-seriousness about environmental issues. We are not going to be a
This
party.
is not IF filed by the government of India, Lord. That's I'm only informing the
If
Lordship.
everybody is happy, then they
That
will
is what
go.
they say, Lord, that they have received the representation, they have forwarded it to the state government.
It will
And they
be
have asked
on.
for a report from us.
It will be on and on and on. There is no end to it. The fact remains that the law of the land, as on date, has not been heard. Whatever be the reason, we do not know. The compliance of law, so far as environmental issue is concerned, cannot be postponed.
That is the issue, not in the case. Compliance of environmental notes law.
On merits,
Day to day, if a new policy is going to come,
Probably not.
in anticipation of a
I'm
policy,
led to believe, no, that as far as what are the proceedings in the pleading says, there is going to be a change in note policy. Maybe the note penal clause of 5 times of the compulsory effort is simply getting reduced.
somehow I came to know
Twice or
that.
thrice.
Somehow
That is
I
what
came to
it
know that
hasn't happened.
there could be afforestation in other states also.
No, that is not permissible now. Earlier it was that I could have bought any piece of land elsewhere, but now they say no, it has to be in the state. Government of
It is
Jharkhand
only
has to
for-
stand to gain.
It is for central PSUs only, that particular clause. It's not applicable on private laws.
So we will decide. We will not. Environmental issues are very serious.
Tomorrow there may be a policy shift, no, I think only the central government can say that.
Merely because, Mr. Rajan, please appreciate, merely because there is a policy shift or there is a likelihood of policy shift, the industry cannot go on like this. And the case cannot go on like this. We will just say, if there is a policy shift, they will have a benefit of policy shift. We just don't want
That
to
would
say
not-
anything
will not-
more.
will not-
In anticipation of a policy, the case cannot.
But these are two parallel lines
As on
here.
today, my lord, the compulsory afforestation has been done twice of the notes diversion. The demand was for 5 times. I think what they are expecting a change in policy that it will be reduced
See,
by 3 times. So
Whatever.
again, it is achievable for them, but as of now,
We're
it
almost
is.
there.
Whatever be the thought process of the petitioner and the respondents.
Yes.
But this court will only see as to whether they have complied the letter and spirit of the environment.
Fair enough.
Miss, can I just
Because any industry, both are beneficiary of that industry. The state is also a beneficiary, the people are also beneficiary, the petitioner is also beneficiary. But if the environment is at a loss, then everybody is a sufferer of that. And that loss is absolutely irreversible. So it is not even a case of injunction.
But perhaps can I just refresh your Lordship's memory? We had an environmental clearance that was revoked. That is
I
a
know.
Yes. So it is not that we were operating. Now the environmental clearance was revoked on a very simple ground that there are forest land is involved or you have changed the location. These are the issues. Now the subsequent developments of all we are discussing are because of the indulgence given by your Lordships and that you must apply and
But
put
it
a
has
quite.
not worked out.
It has not worked.
So we will
There is no
decide the
dispute
case
about it.
on merits.
So we will have to go back. So it's not a case where we are running the plant without any environmental clearance that we never had. So it's we are meeting all the requirements. The State Pollution Control Board regularly monitors the emissions, etc.
As it is that Lokayukt issue and those findings, everything has gone. That also you bring it on record. I don't know whether you have brought it on record or not. You don't take care of that because there are certain observations made therein. And there are certain fallout of that particular order, or you can just serve them that this. It's better if you put it on
I will
record
file
because
affidavit
Union of
Monday
India
itself.
might not be knowing about it.
Monday, I file it.
लोकायुक्त का कुछ एक पर्सनल पेनल्टी पर कुछ ऑर्डर that has been कुछ था, I don't remember exactly.
Lordships have set it aside for the matter to be tasted in a appropriate form.
I don't exactly remember the content, but that may have some bearing.
Yes. Can I make a last attempt to satisfy your Lordship that can it come on second or second half? It may not end. I also know. I know it won't end on second. I'm very aware of it. And
No,
the
and
concern
then-
is genuine.
And
The
then
concern-
it will go beyond
yes,
summer
that
vacation.
also. But there's no hide and seek. We all know how it
On
works.
first.
Yes,
On first you start.
we'll start.
On first you start.
Well.
And if you want to prepare some note, please do it. Union of India is the most contesting party. State is supporting them always. You are the most contesting party, so much lies on you. State तो naturally support करेगा. State की industry है तो support करेगा. Concern है भाई. Certainly.
30,000 employment and
Certainly, sir.
that in
Yeah, that is why it is pending since 2018. Because of 30,000.
issue of pollution and not environmental hazard is only to the extent of how much compulsory compensation should be taken. So that not whether 2 times or 3 times or 5 times is the issue. Not that not the
Now the
industry
issue
as such,
would
not
be-
as so hazardous.
Just
It requires a
now
short
let us be very clear on this. We will everything whatever has happened, the matter has gone again to the environment.
My lord knows
Ministry,
that for all
etc.
of it.
It is by virtue of the some kind of indulgence given
Yes,
by this court
yes,
and
yes.
then the matter is gone.
My lord knows all the
Since
legacy.
it has not crystallized,
Yes,
therefore what remains is the records of the case.
correct.
So we will go strictly by the impugned
Entirely
orders,
subject to
the
what my lord
impugned
should say.
action.
Yes.
Only these things we are going to take care. And then whatever are the allegations, then we do not know whether such kind of dispute, whether actually there was a shift or not, is something which can be decided in a writ jurisdiction.
So there was a
Something
shift. There was a shift.
That is
Factually,
why I
that
there
is
no
an
dispute.
admitted.
There is no
And that is
dispute.
admitted and approved. That's our case. That you had approved the shift of location. There's no dispute on facts.
Diversion of 183 or some hectares of land
And
for
one more
forest.
thing, the environmental clearance is given post afforestation normally or
Yes.
pre afforestation.
Post. It is subject to a grant of FC. The in
That is the
principle
condition
approval is
of-
made subject to a grant of FC. That we have to get FC first, then a formal EC comes.
Okay.
So our case all along has been that there is no forest land and there are not part of the land is covered by judgments of civil court. Suddenly, without any basis, they said no, this is a forest land, therefore we'll revoke it. So all these contests are there. It is not that we were trying
Even if it is a private property,
to. Yes.
then also forest is not to be removed.
It is not. It was not recorded as forest land. If it is a non-forest land, then FC does not come. It's only a forest or deemed forest. We say
Provided, so that dispute is pending.
that dispute is pending before the civil court for a part of it. Let us be very clear, for a part of it.
Not the entire of it.
Not of the entire of the land. But that dispute is being pursued. But till the dispute is decided, Manoj, we will have to go by
What
the
is the percentage of that land which is subject matter of suit?
17 acres, which is the dispute.
So it is just a portion of the.
But the notification is the same. case is based on notification of 1958, which the Forest Department of the Jharkhand government realized.
No, out of the entire chunk of land
17
which
acres is
you
in
are
dispute.
which you are occupying, and then the requirement of environmental issues. If only a small portion is subject matter
No,
of
see,
suit.
other land is also they are claiming it's forest. Beyond 17 acres is
No,
under litigation.
but it is rest is not under litigation.
So therefore we say it's not forest, but they are saying no, it's forest. So therefore it is the point is matter in a criminal case went up to Supreme Court. It said for the state of Jharkhand.
Around 10% of the land what is in a dispute. Otherwise not. Rest
So
of the
this
portion
is
is
the-
the forest area.
So we have to segregate that how much is disputed forest, how much is admitted forest.
Admitted is zero. Disputed
Admitted is zero.
Yes, we are not saying it because we have a point, and our arguments have been appealed to Supreme Court so far as the notification is concerned. We'll thrash that out. Therefore, it's a case where we have been compliant. There have been some subsequent developments which or legal issues, but not as much. The advocate said there is no pollution or emissions which are beyond control. Nothing of that sort.
Issue is only with regard to compulsory afforestation to be provided. How much more they have already done 2 times. Now.
What was the reason for cancellation of forest?
That there is for a cancellation of the
Non-compliance with the state
EC two. One, that you have this is a forest land, suddenly they say this is a forest land, and number 2, there is a change in location. These are the 2 basic issues for revocation.
So change in location has been taken care of.
We say that change in location, the needy, which was the consulted, submitted report, and you approved by the competent authority, they are saying no, it was never approved. That's a legal issue. We can show. And this forest issue is also purely legal issue. Whether the notification on which the forest department claims is a final notification or not. It's a transitory. That's a dispute.
So therefore, the notification on the basis of which forest department is claiming that it is a forest land
It's not a final.
is not supported by entries made in the Khatiyan.
Right, that is the point. Now 29(3) proviso has been invoked, which itself says that this notification is subject to the rights of the people there. So the rights have never, that has to crystallize by virtue of revenue record ultimately saying this is a forest, which has never been.
In the Khatiyan, it is not recorded as
So
forest.
the 17-acre dispute which we want shows we are the my vendors were occupancy rights and it's not a forest land. The word used by the trial court, the notification is a means.
So it will require interpretation of section 29.
29(3) proviso. We have judgments for supporting us.
Give some whatever judgments we want to cite and give advance written notes. You can always supplement. There is no
we have
problem
prepared
about
notes. We were 11th the matter was anyways coming up. Let us be very
If
honest.
you have prepared whatever you have
Whatever
prepared,
we
you
have
can just submit
Yes.
for having a bird's eye view. Such that I
Compilation we
also
have-
read it.
we
If
have
you
probably
have it,
given.
please give it to
No,
us.
compilation we had given already.
देखिए तो इनका कोई compilation
Convenience compilation we had given. Just we, I think we also.
This one?
No. Huge.
That compulsion.
Judgment for compilation.
The compilation will be sought upon us.
ये the pleadings and all that we had brought it एक जगह कर दिए.
अच्छा
Convenience के लिए.
हाँ convenience compilation ये दिए हैं आप
हाँ दे चुके थे hearing और
Spiral binding.
हाँ spiral में करके दिए थे so that
नहीं बस
हाँ नीचे वॉल्यूम 2 वॉल्यूम
आपको भी दिए हैं
हाँ इनको
हम लोग को नहीं
फिर देता हाँ आपको भी दिए थे
मिला
नहीं ऐसा होगा
तो 2 volume.
what I'll do is minutes today I'll make another copy and hand it over to the lordship's office.
it is continuously numbered.
Yes.
It has an
So,
index.
It has an index continuing of all pleadings of both the cases at one place. नहीं ये नहीं
All pleadings of both the cases at 2 different volumes.
Yes, two different.
No, it doesn't appear to be.
No, it is not that. These are let us not waste time on this one.
ये वाला नहीं.
It can always be given
Yes,
afresh.
we are giving it then. And judgment and notes will try and give it by Tuesday or Wednesday.
जितना भी इनका adjudicatory applications है ये सारा अलग है ये तो पेंडिंग वाला अलग है पुराने भी अलग कर दीजिए पूरा रिकॉर्ड से छांट के सब एकदम आइए सब अलग कर दीजिए ठीक है और इनका जब रिकॉर्ड आएगा तो हाउ मच टाइम यू नीड टू प्रोवाइड इट
The compilation. Compilation today only. आज कोशिश करते हैं आज शाम तक हो जाए तो कभी आज शाम को हो जाए.
दैट इज ऑल
So
First
first
come on first.
on first 10:30 हम लोग ऐसे ही करेंगे। क्या होगा?
हाँ,
आई टेल
हाँ।
यू वन थिंग, कुछ वॉल्यूम से कुछ नहीं,
नहीं
शुरू करने से खत्म हो
हम तो
जाता
कह रहे थे इशू तो बहुत छोटा है
एंड वी हैव डन इट ऑन अर्लियर ओकेजन्स आल्सो, वी हैव डन इट। क्या होगा? पूरा दिन एक ही केस डिस्पोजल होगा, हो सकता है एक भी नहीं हो, इससे कोई फर्क नहीं
12:30
पड़ता।
से पढ़ते तो हम लोग
12:30 से नहीं, 10:30
एडवोकेट 10:30 onwards
एडवोकेट जनरल विल बी हियर। चलिए, with the consent of the learned counsel for the parties, post this case for final disposal on 1st of May to be taken up from 10:30 onwards till it ends. And if required, it will continue on 2nd of May.
इसको नहीं लिखा था लास्ट पर
And
वेरी
ये इसलिए है कि आपके सीनियर को पता होना चाहिए कि पूरा दिन यहाँ लगाना है तो कितना फीस लेना है,
दैट आई हैव ऑलरेडी स्पोकन
बाय आवरली लेना है, बाय मिनट लेना है। नहीं नहीं हो सकता।
दैट दे ऑलरेडी डिसाइडेड
दे मस्ट हैव सोचे होंगे बहुत खचखच वाला कोर्ट है
नहीं
तो थोड़ा सा ज्यादा टाइम लेंगे।
वी आर वेरी हैप्पी विद द मैटर सो
We'll hear it. एक बैलेंसिंग तो we will see
Yes,
where does the balance lie. बस इलीगल ऑर्डर मत कराइए,
नहीं
गलत ऑर्डर मत कराइए। अगर मान लीजिए प्रोविजन ऑफ लॉ रेड विद 226 में भी कुछ भी पॉसिबिलिटी है तो we will certainly explore it, but not something which is beyond permissible limits. And Union of India will certainly have lot of responsibility.
Item 5, same to city of 2021.
Sorry,
Now we have adopted a middle class.
क्या
This
करें?
side or that side.
देखिए, I'll tell you one.
Sometimes we
If
have
you-
to choose the path.
हर चीज 100% फूल प्रूफ जैसा कुछ नहीं।
Go is there are controversies and incontroversies. You know that.
थोड़ा सा देखिए,
If there is a possibility and if there is a chance, then it should be given
the
the chance
point
to be
is
not,
that if you cast an obligation upon a person
they have to put
which is impossible to comply, then where do you stand?
yes.
तो ये थोड़ा सा देखेंगे, let us see.
No, but any penalty also must be reasonable. That's the now the government of India is thinking that 1:5, 1:2 becomes unreasonable on anyone's part, and it does not serve any purpose. It doesn't serve any purpose. Now, pollution in Bokaro, I find land in Garhwa. The ecology doesn't get better in Bokaro.
No, ऐसा नहीं है.
हाँ?
Ecology doesn't is not in pockets.
It is not. But I'm saying the idea is not to have lands all around, but it was unreasonable according to us. 6 times it was highly unreasonable. We are ready to pay the value. It is not that we are shying away from paying the money. We could have compensated otherwise. But these issues will only come up as a secondary matter. Right.
Item 5, similarly city of 2021.
What is this IA? IA क्या चीज का फाइल? What is this IA? ये फाइल करके आप यहाँ पे खड़े हैं, आपके पास फाइल नहीं है। उनकी सिविल रिव्यू क्या चीज का सिविल रिव्यू? किसका ऑर्डर है? मेरा ऑर्डर है। Are you standing here without a file? फाइल क्या? निकालिए पेज नंबर 27। टेक आउट पेज नंबर 27। नहीं है ना? लिखिए Civil Review number 60 of 2021.
So Anil Kumar
Learned counsel for the नाम बताइए नाम बताइए अपना
Sachin Mathur.
Sachin Mehta. Mr. Sachin Mehta appears before this court and upon asking submits that he is not in possession of the file. Posted 2nd of January 2026. Aram Sally.
Item 6 CMP 183 of 2024.
Restoration matter. Defective है डिफेक्टिव कैसे हो जाएगा देखिए CAP number 183 of 2024. Nobody appears on behalf of the petitioner. However, time till 10th of June is granted to the petitioner to remove the surviving defects preemptively. If the defects are removed within time, post on 13th of June.
Orders item 10 CMP 726 of 2022.
ये भी defective है?
Item 10.
This is for the restoration materials.
Restoration of second appeal.
Second appeals.
CAP number 726 of 2022 with IA number 11010 of 2022 seeking condonation of delay in filing this CMP. The matter arises out of second appeal number 141 of 2018. Let notice be issued to the respondents for which requisite under ordinary process be filed within a week.
This is the defect you can
कौन सा defective
This matter is dismissed default here also. Errors. And that has been restored first.
Sorry. जब आपका सेकेंड अपील में एप्लीकेशन फॉर रेस्टोरेशन इज बार्ड बाय लिजिटेशन, बिना नोटिस के डिले कंट्रोल किए हम रेस्टोर नहीं करेंगे, ठीक है? आईए में भी नोटिस होगा और मेन सीएमपी में भी नोटिस होगा, राइट? गॉट इट? रिक्विजिट्स भी फाइल बाय 10th of June, दोनों में, आईए में भी सीएमपी में. Post this case on 15th of July for waiting service. फर्स्ट अपील सेकेंड अपील अगर डिसमिस हो जाए ना तो बस बहुत ही ज़्यादा मुश्किल है. डिसमिस फॉर डिफॉल्ट.
This will default असल में the previous council has not filed.
कोई बात नहीं, ऐसे रेस्टोर होने में आपका हालत खराब हो जाएगा. तो देखिएगा, अभी कोई रिपोर्ट आएगा किसी का डेथ हो गया, कोई अवेलेबल नहीं है, बहुत मुश्किल है. फर्स्ट अपील सेकेंड अपील DFT is very serious.
Earlier council was another दूसरा council.
Item 12 CMP 799 of 2023.
What is this? Restoration. Defect है.
In the restoration petition, so many defects are pointed out, and by order dated, last order dated 28/2/2025, time was granted to defect that, if there is any survival defects, or to file an appropriate application. In this application, we have stated we have removed most of the defects.
What is 4, 5 and 6?
Yes.
What is defect number 4, 5 and 6?
That is the paragraph 5. Out of the defect pointed out by the
There are surviving defect number 4, 5 and 6.
yes. With 4, 5 and 6, I have stated that that out of the defects pointed out by the concerned section, the petitioner of paragraph 5 have already removed the defect number 4, 7 and defects number 8 and 9. But all the defects mentioned in against defect number 5 and 6 have not been removed as parentage of OP number 6 to 9 are not mentioned in the own judgment and degree of the applicant. Therefore, it is to be corrected by the court below. And paragraph 6, that so far the defect number 6 is concerned, it is stated that the address details of the PO and PS district name of OP number 1 to 4, 36 and 37 have not been corrected, but correction so far the address details of the PO, PS details district of PO number 5 to 9 have not been removed as the details of the PO, PS district of OP number 5 to 9 are not mentioned in the judgment and decree, and hence the defect either to be ignored or maybe sent before the court below for necessary correction. And another
Just a moment, if PO, PS and district is not mentioned,
yes, how
then
the degree has been passed, when we have that question, how the parentage has not been given, how the degree has been passed, so many defects.
and degree in if in the plaint it is not mentioned, it is not mentioned. But for issuance of notice also we need, if not the parentage, we need PO, PS and district.
Yes.
Do you want to say that without any district that
No, I
notice
have
can be
said,
issued?
that's why I say, my lord, that
Then?
it may be sent before the court below for necessary correction. And there
No,
is
we do not know whether in the plaint also
Nahi
this
hai.
description has been mentioned.
No,
or
I
not.
have stated that that is
नहीं होगा तो डिग्री कैसे करेक्शन होगा? What is the means by which it can be
the
corrected?
details will be given by my client. And previously it was also sent for correction. Paragraph 8, kindly see that. And some defect was removed by the court below and some was not. But at this stage he is ready to give all the details. Paragraph 8, that it is further stated and submitted that the previously also by an order dated 3/12/2020, paragraph 8 I am reading. 3/12/2020 passed in essay number, second appeal number 513 of such and such, defect number 21 to 29 were sent to the court below for necessary action. And after some correction, file has been sent by letter dated 12/2/2021, wherein some defects have still existed for which further order and direction may be passed. This then my lord,
This is all in connection with defect number 6.
no, or some
No, you say that you have already removed defect number 4, 7 and 8.
yes, I have removed that defect. Apart from that, there is another defect also, parentage PO post office district has not been mentioned. That is still exists. And the letter which has been sent by them, it has
I'm
been
not able to get it. You read paragraph number 5. You said defect number 4, 7, 8 and 9 have been removed.
yes.
Right? Four, 7, 8 and 9.
Yes.
Okay, there is no surviving defect with 8 and 9, but defect number 4 as per the office note is still existing.
Yes, I have removed the defect whatever mentioned in the yes, my lord, defect number that is with me. Paragraph 4, the defect is that defect number 4, my lord. 4 is name of the petitioner number 5, not mentioned. That is not mentioned. That is slip which was given for removing the defect. Name of the petitioner number not mentioned. That is not mentioned in the original decree also. OP number 35, 53, 64 and parentage of 1 may be corrected in the memo. Amongst that, we have corrected already removed defect 4, 7 and defect number 8 and 9. Defect number
You,
8.
you say that defect number 4 you have removed, but
Yes.
office note says that defect number 4 is existing.
Before that, now
I have the fresh office note.
defect number 4 is
Existing.
out of 4 petitioner is already
ऑफिस नोट नहीं पढ़े ना, दिखाइए इनको ऑफिस नोट. Show the office note.
name of the petition number 5 is not mentioned, therefore we have said it is correct.
You say that defect number 4 has been removed, now you see the office note. Please go.
Yes.
Item 13, CMP 150 of 2024.
What is it?
It's a CMP for restoration of another CMP. Now there is a defect that is pointed out that there is a delay of 700 days. So we have filed one IA for condemnation of it.
This is writ.
Yes. Originally it was a writ petition, it was dismissed for non-appearance, then subsequently CMP was filed. That CMP also stood dismissed for non-prosecution, and we had filed one CMP that the order we have annexed with page 12 of this present petition. That CMP, when we filed the CMP for restoration of it, we came to know that earlier a CMP was also filed, and it also stood dismissed. So that detail is at page 12 of my main CMP petition, that order. So we took liberty to take appropriate step for restoration of that CMP. So for that CMP, we have filed this present CMP for restoration. And now there is and during this transition, there is a defect of limitation which has been pointed out, 736 days, and there is one IA that we have paid for condemnation.
What do you say?
Yes, sir. Also, there is a delay of 736 days in the restoration process.
The council who was earlier engaged, he has also passed away during this period. No information could be passed on.
Who has passed away?
Mr. B.P. Titarve, he was engaged in the
Writ.
writ
When did he pass away?
in the corona time.
And when was the writ dismissed for the
Writ dismissed in 2018.
So,
2018.
so when he was there, the writ was dismissed.
When he was there, it was dismissed, but then when he came to this petition, went on inquiring about this case, then that is why it was taken up. Means we were engaged in this case subsequently, but then again we filed in CMP. In that CMP, we came to know that earlier also there was a CMP which was filed, and that CMP also stood dismissed.
CMP number 150 of 2021, with IA number 3179 of 2025. The learned counsel for the there is no private party.
There is one private party.
There is a
That would be respondent number 6 in CMP.
respondent 6. Counsel for the neglect notice be issued to respond number 6 in this CMP as well as in the regulatory applications into contribution. Through the concerned police station for which requisite be filed under ordinary process by 8th of May. Post this case on 18th of June, awaiting service. 18th May, 21st of June. The counsel for the state is directed to seek instructions from the officer in charge of the concerned police station and file affidavit regarding service of notice upon respondent number 6. And at the time of serving the notice, the Aadhaar card of respondent number 6 be taken and notice be served in presence of witnesses. फिक्स डेट है उनका 20 तारीख, आप एफिडेविट 16 तारीख तक कर देंगे, दोनों में नोटिस है। एक बार आ जाएंगे ना तो उनको रीट वगैरह सब में फिर एप्लीकेशन। You see, in all the cases where tribals are there, उनका आइडेंटिटी बहुत जरूरी है, because we are coming across cases, कोई भी रिसीव कर लेता है, उसके बाद यहाँ चल जाता है प्रोसीडिंग, उसके बाद अगला के बोलता है हम तो नहीं, हमें तो नहीं मालूम।
इसमें तो हो भी सकता है because it's a rising of a CMT act. So let's see.
इसीलिए वो CMT देखकर ही अब नोटिस सर्विस प्रॉपर होना चाहिए।
Item 15 CMP 280 of 2025.
हाँ बताइए। Restoration of
Restoration of email 302/2020, which are dismissed for not complying with the period of consideration. And there is delay of 63 days also in filing the CMP document. Paragraph 26 in IEB explained.
बिना नोटिस के कैसे होगा? इंश्योरेंस कंपनी की तरफ से आप LIC क्या करना है? रेस्टोर कर दे, बताइए, रेस्टोर कर दें, क्या करेंगे? क्या ही करेंगे? डिफेक्ट नहीं रिमूव किया होगा।
हाँ, डिफेक्ट नंबर 1 का हम लोग फाइल कर दिए, IF लिमिटेशन केस में फाइल करना है, लेकिन प्रिंट ऑर्डर के बाद में फाइल किया है। डिफेक्ट नंबर 2 बस जो ऑथेंटिकेशन फीस फाइल करना था, सर्टिफाइड कॉपी वही फाइल किया।
CMP number 280 of 2025. Counsel for the parties are present. With लिखिएगा, with IA number 13735 of 20. Counsel for the parties are present. A dilatory application has been filed seeking condonation of delay of 63 days in preferring this petition, this CMP. And CMP has been filed for restoration of MA number 302 of 2023, which stood dismissed on account of non-removal of defects on 31/3/2024 in terms of order dated 6/8/2024. The learned counsel for the petitioner has referred to the interlocutory application for condonation of delay and has submitted that
Paragraph 4
and has referred to paragraph 4 thereof.
4, 5 and 6.
4, 5 and 6. The learned counsel has also referred to the CMP application and has submitted that only certain minor defects were required to be removed, and a petition for condonation of delay was also required to be filed in the MA application.
Yes, doctor. We have IA number 9557 of 2020. The same was filed after the date of on 3rd September.
Yes, but appropriate steps could not be taken within time, and consequently the MA has been dismissed. He submits that due to inadvertence, the defect in MA could not be removed within time, and prays that the delay be condoned and the MA number 302 of 23 is restored to its original file. The learned counsel for the respondents has no serious objection.
Respondent of whom?
वो भी तो हैं दूसरे।
इसी केस में बोले क्या?
Respondents have no serious objection to the prayer for condonation of delay and restoration of MA. Considering the aforesaid submission and being satisfied with the cause shown, IA number 13735 of 25, seeking condonation of delay in filing CMP number 280 of 25 is hereby condoned. So far as CMP number 280 of 25 is concerned, the time for removal of defects granted by order dated 6/8/2024 in MA number 290 of 2023 is extended till 11th of June. The CMP is accordingly dispatched. If the defect in MA are removed by the extended date, the office is directed to place the MA before appropriate date as per procedure.
Item 20, CMP
उनका भी नाम दे
451.
देंगे ना?
इसी केस में तो वो मुकदमा मैं इस केस में उनका भी नाम दूंगा।
तो CCI कौन है?
अमित कुमार सिन्हा का नाम है।
अपीयर कर रहा है? मिस्टर अमित कुमार सिन्हा को बुलाइए भाई, उनको बुलाइए। Inform him. I will record his appearance. Mr. अमित कुमार सिन्हा, अमित कुमार दास होंगे ना? अमित कुमार सिन्हा, अनूप कुमार मेहता की जूनियर कहाँ है, उनको बुलाइए।
Item 20, CMP 451 of 2022.
Your CMP for restoration of WPS.
कब का रिपीटिशन है?
2019.
ये डिफेक्ट नहीं रिमूव किए थे, क्या किए थे?
Lordship, it was conducted by some other lawyer, and it was not defect was not removed for battery.
CMP number 451 of 2022. State है, दोनों state of Bihar, state of Jharkhand दोनों.
I got Bihar now.
Where is the council for the state? State of Jharkhand. CMP number 451 of 2022. This petition has been filed for restoration of WPS number 750 of 2019, which stood dismissed for non-removal of defects in terms of order dated 26/4/2022. The learned counsel for the petitioner has submitted that the conducting counsel of the writ petition did not remove the defects, and consequently the writ petitions to dismiss for default. He submits that the matter relates to post-retiree benefits. The matter in the writ petition relates to post-retiree benefits. Counsel for the respondents has no serious objection for restoration of the writ petition. Consequently, the time for removal of defects in WPS number 750 of 2019, as granted by the order dated 26/4/2022, is extended till 11th of June. If the defects in the petition are and the CMP is disposed of in their posted terms, it is further observed that if the defects in the petition are removed within the extended time, office is directed to place the petition before appropriate bench as per roster. टाइम आपका PMP ही रह गया है, आपको प्रेस वकालतनामा फाइल करना पड़ेगा.
I'm filing the press for that.
आपको बता
Your Lordship, I will be
तो
allowed
फिर
to
हो
file.
जाएगा आपका DFD.
In case the defect are incurable in nature.
अरे वो आपको करना भी do not do, आपको काफी टाइम देना, छुट्टी में बैठ के यही सब करना. Defect review.
Item 21, Contempt of 650 or 2022.
What is it?
They have filed so-called supplementary affidavit. They had to take decision. Your Lordship had one way. No, Lord, this decision is no decision at all. Now, Your Lordship may see this decision. Lord, what they say about employment. They are not denying it. They are not given it.
Page number 11 of the supplementary.
Yes, what is it? After scrutiny of records. Yes.
उसमें C नंबर में employment के बारे में लिख रहा है. Employment shall be governed by CIL R&R policy 2012 or any other R&R policy of the company prevailing at the time of acquisition, registration of the land is the BCC. Your Lordship had directed them. और उसके ऊपर में हम जो सप्लीमेंट्री फाइल करके जो डॉक्यूमेंट्स दिए थे, तो उसके बारे में कह रहे हैं कि अभी भी नहीं मिला है, तो हम लोग कुछ नहीं कर सकते.
What is the nature of order? Yes, comes.
Yes. Page number 8. Annexure 188. Was in accordance with law. So we have
You
to
see,
give
they
according to
are
the policy.
asking you to give no objection for transfer of land. So these are the formalities that you have to do. They have, you see, there is no direction that you should be given something. They were asking you to produce some documents, but at that point of time, the petition was disposed of. They have passed some order. You can't do anything. You comply on this, then you'll have a
We submitted before your Lordships that this much document is only with us. Your Lordship directed us, you file supplementary, what documents you are having, and they were directed to decide this case on the documents which we were
You see,
filing.
they are asking you to take due permission under section 49 of Jharkhand tenancy act.
तो होगा ही, मतलब they are
होगा ही मतलब?
they are, yes, we will cooperate.
तो कोऑपरेट करिए ना, आपको कहाँ मना कर रहे हैं? ये जो भी कंडीशन ये लगाए हैं, इस सेक्शन 49 का आपको CAT एक्ट का कंडीशन है, आप लेके चले जाइए. Now they have given you that if you comply that, they will act as per their policy. इसके बियॉन्ड नहीं हो सकता. ये दोनों नहीं चलेगा ना, ट्रांसफर भी नहीं होगा और सब मिल भी जाएगा. इससे दोनों नहीं चलेगा. Contempt case civil number 650 of 2020. Counsel for the parties are present. A show cause has been filed on behalf of the opposite parties. Bringing on record a recent order dated 8/4/2025, whereby certain conditions has been put for giving benefit to the petitioner.
सेक्शन 49 जो है वो इंडस्ट्रियल पर्पसेस के लिए डीसी से परमिशन हो करके सेल होने का, लैंड ट्रांसफर होने का. Lord, they are
Just a moment, please hold on. counsel for the petitioner has submitted that the reasoned order is not in tune with the spirit of the order passed by this court in WPS number 4504 of 2014. After going through the order passed in the writ petition and upon going through the reasoned order, this court is not inclined to proceed any further in this contempt proceedings. However, if the petitioner is agreed by the reasoned order or wants to comply with certain directions which has been issued in terms of the reasoned order, it will be open to the petitioner to take steps as may be permissible.
Item 22, Contempt Civil 795 or 2020.
As per the office code, defect number 4 is still surviving. Do you want to say that you have cured the defect?
Yes, yes. Can you see that? For the defect was name of the petition number 5. Name of the petition number 5.
And opposite party number 3, 5 and 64.
35. Opposite party number 35.
35, 53 and 64.
All have been corrected.
Yes. And what about parentage of petition number 1 to 5?
Yes, Honorable. So far against that, but can you see that paragraph 5? The petitioner has already removed the defect number 47. 477 में क्वेश्चन कुछ नहीं है. Defect number 8 and 9.
आप 8, 9 में मत पहुंचिए, आप सिर्फ 4 तक कन्फाइंड. 4, defect number 4.
Yes, 4 में तो
64 also you have completed. 64.
64 except 64.
Why 64?
Because the parentage has not been mentioned. Parentage of petition number 6 and 9 is not mentioned.
6 and 9 का तो बात ही नहीं है defect number 4 में. Defect number 4 is petitioner.
Defect number, yes, I mean, defect number 4 is the petitioner.
Petitioner number 5.
5, it has been corrected. OP number 35, can you see that? It has been corrected.
OP number 35, 53. What about 64?
64 is also corrected. 35 is corrected. 26 not is corrected. And 64.
Yes.
Yes, 64. Kaushalla Mahato. Devi has been written, it has been corrected Mahato. It has been corrected.
उसको son of लिख दिए.
Son of Kaushalla
Wife of को काट के son of लिख दिए.
Son of है.
कौशल्या is lady or what? Son कैसे हो जाएगा?
Is son of daughter of.
We do not know daughter है, पहले wife of लिखे थे, अब son of लिखे हैं.
Sorry, daughter of.
Daughter है कि wife है कि क्या है?
No wife.
Okay. CMP number 799 of 2023. The learned counsel for the appellant prays for 1 week time to remove the surviving defect. She has submitted that defect number 4. She has submitted that defect number 4 has been partly removed and there are certain surviving error with respect to opposite party number 64. She may do the needful within a month. She has further submitted that IA number 4066 of 25 has been filed, mentioning that defect number 7, 8 and 9 have been removed, but so far as defect number 5 and 6 are concerned, the same could not be removed as there are certain discrepancy in the degree itself. She submits that the defect number 5 and 6 be ignored. Considering the efforts and submissions, the defect number 5 and 6 are ignored for the present. अब 4 आप रिमूव कर दीजिए. अभी करेंगे. वाइफ है कि हस्बैंड है कि क्या है?
Daughter.
कैसे पता?
Because that is the landed property under.
ऐसे बिकॉज से मत बोलिए भाई.
अच्छा ठीक है.
चेक करके पता करके बोलिए. ऐसे नहीं बोलिए. 1 वीक आपको टाइम दे दिया इसको. 5, 6 को इग्नोर कर. पोस्ट ऑन नेक्स्ट फ्राइडे.
No matter. So for the other.
नेक्स्ट फ्राइडे नहीं होगा. नेक्स्ट फ्राइडे.
Other defects is concerned which has not been corrected by the court, you know, even if the.
वो तो सब आपका 5, 6 पूरा इग्नोर कर दिए.
5, 6 ignore करते हैं.
4, 5, 6 तीन ही डिफेक्ट बचा है. 4 पार्टली रिमूव्ड है. You do the needful. 5, 6 पूरा इग्नोर कर दिए.
Much होता है. ठीक. And
बाकी तो आप रिमूव कर दिए.
बाकी हम रिमूव कर दिया. Other defect which has been pointed out.
There is no further defect.
I see.
If there are any other defect, it will be open to the petitioner to remove the same.
No, that will be
तो आपको तो नहीं दिखा कोई other
that will be sent before the court below.
That will be sent once the second appeal is restored.
To that
यहाँ से तो नहीं भेज सकते.
There is a light. To that extent.
Item 22 contains 795 of 2022, along with item 23 and 24.
The issue that concerned LPA is on judgment stage. It may be kept after 3 weeks after the judgment.
Arguments concluded.
Yes, sir. It is on judgment stage.
Contempt civil 795 of 2022. Counsel for the respondents. Opposite party has submitted that the matter has been finally heard by the Honorable Division Bench and only the judgment is to be pronounced. In all these 3 cases,
Yes.
interconnected petition.
In 2 cases.
Interconnected appeal.
2 cases. Krishna Prasad Mahto is another.
अब तीसरा?
That is.
तीसरा का क्या होगा?
It is. It has not.
There are
been
only 2 cases here.
3 cases.
तो तीसरा केस में LPA नहीं हुआ.
LPA हुआ है. LPA हुआ है, but it has not been taken up. 2 cases have been taken up. Umapati Pandit and Banaras Prasad Rai. And third one is Krishna Prasad.
Serial number बताइए.
Serial number 22.
22 का अभी पेंडिंग है.
Yes, sir.
हियरिंग किसमें कंप्लीट हुआ है? सीरियल नंबर
23 and 24.
सीरियल नंबर 23, 24 में हियरिंग इज कंप्लीट. कब करते?
After 3 weeks.
He prays that the matter be posted after 3 days. Post on 13th of June.
Item 25, CMP 842 of 2022.
Last date notice is sentence. Dated 14 to 25.
So what happened in the notice?
I'm going to check the.
This is CMP.
Yes.
CMP number 84 of 2022. Counsel for the appellant has submitted that he has not been able to go through the office note. Post this case on 7th of November. चलिए, आप आराम से ऑफिस में.
He is
Good. 7th November कॉल
Item 26 contains 860 of 2022.
थोड़ा डेट 7 नवंबर से पहले का
क्या चीज़?
डेट थोड़ा पहले.
आपके हिसाब से डेट नहीं फिक्स होगा. जब आप ऑफिस नोट नहीं पढ़ सकते हैं तो क्या ही जल्दी है इसका? देयर इज नो अर्जेंसी. अच्छा इसी साल हो जाएगा, नहीं तो 2 साल बाद भी रख सकते हैं. रेस्टोरेशन का कोई अर्जेंसी नहीं है.
रेस्टोरेशन का मैटर नहीं.
आपका वो फर्स्ट अपील का रेस्टोरेशन है.
That is, this is a CMP arising out of a CMP that was filed for restoration. It is only for that portion of the CMP in which your ladyship had directed for payment of some amount. Owing to the financial condition of the petitioner is filed.
I just don't know.
Any prior date of if
इसका
permissible.
बताइए इसका.
इसमें लीव ग्रांट हो गया है और ये टीए को फिर से सुनवाई के लिए अपेक्स कोर्ट का डायरेक्शन हुआ है. दिस इज द ऑर्डर फॉर द अपेक्स.
आप किस ऑर्डर कर रहे हैं इसके लिए?
फिर पीए में जो लिमिटेशन के ग्राउंड में डिसमिस हुआ था अगेंस्ट दैट
Now the LPA has been restored. इसके बाद LPA नंबर कौन सा?
इसमें जो डेट फिक्स हुआ है मैं किया गया है कि मैं
May.
लॉर्डशिप में kindly see second page. We direct the parties to appear before the appellate court on 6/5/2020.
Okay. Contempt case civil number 860 of 2022. Counsel for the parties are present. The counsel for the state has submitted that the order passed in LPA number 115 of 2023 has been set aside by Honorable Supreme Court and the matter has been and the LPA has been restored and parties have been directed to appear on 6/5/24. The learned counsel seeks settlement. Post on 1st of August 25 or after disposal of the LPA whichever is earlier.
Item 27, Contempt Civil 102 of 2023.
Order dated 10/10/2022 has not been complied. State has preferred an LPA. However, Lordship, there is no progress in the said. By last order of the LPA, Lordship, there was a direction to remove defects.
Contempt case civil number 102 of 2023. LP number 672 of 22 is still pending. Post this case on 1st of August 25 or after disposal of the LPA whichever is earlier.
Item 28, Contempt Civil 369 of
appearance.
2023.
In this case, Bajaj has spoken as served minor just now.
Contempt case civil
Contempt street
number
में रख दिया.
369 of 2023.
Supplementary so called. Next week में sir.
वो कब
Yes. Complying behind the back of the petition, my lord, it has been complied.
Region order why this 30,000 amount has been arrived at, my lord, that detail has been given.
Similar.
हम उसकी इनकी बात को अपोज नहीं कर रहे हैं, हमने आज दिया, हम आज
हाँ ठीक है बताइए.
हम इसमें सिर्फ एक पारा इसमें है जिसमें कॉम्प्लिकेशन दिया हुआ है कैसे PCR का फिगर निकला. रीजन ऑर्डर में पारा 6 पर आया. इनको मिलता है 30,000 रुपया एक साल में, 2500 रुपया पर मंथ। तो इनका जो फिगर दिया हुआ है पैरा 4 के शुरू होता है 9 से, 9 10, पैरा 4 के 10, 10, 11, A, B, C added together comes to 30,000. Here he paid 30,000 rupees a year. तो कॉमर्स में सिर्फ 8 लड़के हैं, और जिनको कितनी तनख्वाह मिलेगी डिपेंड करता है कितने छात्र हैं उस कॉलेज में और किसको कितना मिलता है। ये अनसैंक्शन फोर्स कोर्स पर हैं, इनको यही मिलता है। इसमें ब्रेकअप दिया हुआ है 9, 10, 11।
The petitioner has been appointed against the sanctioned post, my lord, and the one person, my lord, who has, namely Vedant Sujala, my lord, who has also been appointed against the third post, my lord, and he is getting 84,000 rupees.
देखिए ऐसा है, अब आपको एक तो रीजन ऑर्डर मिल गया है, कंटेंट में तो नहीं चलेगा ना, अब आपको रेक्टिफाई करना है। इसलिए अननेसेसरी देखिए चीज़ों को एक बार सरफेस में आ गया है कि क्या कैलकुलेशन है, क्या रीजन है। Now you have a fresh cause of action. Content में हम लोग
नेक्स्ट वीक में इसका हम जवाब दे देंगे।
नेक्स्ट वीक कोई जवाब का कोई काम ही नहीं है इसमें कोई जवाब का काम नहीं है, क्योंकि कंटेंट में नहीं प्रोसीड। नेक्स्ट वीक तक आप अपना फ्रेश रीट फाइल करें।
ऐसा रीट में कोई काउंटर आया था, इसमें इस तरह की कोई बात नहीं कही गई थी मुझे, और उसके बाद ये ऑर्डर ही पास हुआ।
कोई बात नहीं, इसको कुछ कर नहीं सकते।
इसको नेक्स्ट वीक में रखा जाएगा जब आप कुछ
अननेसेसरी इसको देखिए चीजों को पेंडिंग
नेक्स्ट वीक में मतलब अभी तुरंत कॉपी मिला है, इस वजह से हम करें।
ऐसा कोई नियम है क्या? कुछ देखिए रीजन ऑर्डर इनको पास करना था, इन्होंने अपना कैलकुलेशन
दिस हैज इट पास behind the back of the petitioner, my lord. I will give reply, my lord, then your matter may be disposed of, my lord. Yeah, next week में रख दिया जाए इसको।
कहाँ आपको हियरिंग का कोई ऑर्डर था? आपको हियरिंग का कोई ऑर्डर नहीं था। रीट के ऑर्डर में आपको हियरिंग देने का कोई ऑर्डर नहीं था।
हियरिंग करने को तो ऑर्डर नहीं है,
नहीं था ना?
लेकिन इस तरह का काउंटर फाइल किए थे उसमें कहीं कुछ नहीं लिखा हुआ था।
देखिए कंटेम्प्ट केस सिविल नंबर 369 ऑफ 2020। The learned counsel for the university has filed show cause, supplementary show cause on behalf of opposite party number 2 and 3 and has placed on record a reasoned order. He has submitted that the entire calculation has been mentioned in the reasoned order. Considering the nature of order passed by this court is not inclined to proceed any further in this contempt proceedings. Accordingly, the contempt proceedings are dropped. However, it will be open to the petitioner to take steps in connection with the reasoned order or in connection with any other grievance as may be permissible under
लिबर्टी दे दिया।
liberty they do.
किसी को जो 30,000, किसी को 84,000 यही डिस्क्रिमिनेशन है। Affiliated colon
Item 29, Contempt Civil 534 of 2023, along with item 30.
LPA was dismissed, and earlier Lordship, arising out of same order, another LPA was preferred, same was dismissed, and state has preferred SLP, Lordship.
So क्या करें हम आपको?
Lordship only by submitting my submission.
इस पर्टिकुलर ऑर्डर का एलपीए आपने फाइल, इसको एसएलपी फाइल किया है। ये कौन से ऑर्डर से राइज कर रहा है?
WPA 6160 2015।
तो केस था वो WPS 6160 और
इसमें कुछ पार्टी उनको बनाना बना नहीं
रिव्यू पिटिशन वाज डायरेक्टेड
नहीं बनाए, तो उसके अगेंस्ट में एलपीए कर दिए, तो क्या करना? आपने ऑर्डर का कंप्लायंस नहीं किया। क्या है आपके पास नहीं है? आप रिव्यू किसका था? रिव्यू तो आप ही का था ना? आपने फाइल किया था ना रिव्यू? तो उसको पार्टी बनाया?
against the order matter passed in WPS number
आपका रिव्यू डिस्कस कर लेते हैं. आपको कोई मतलब ही नहीं है ऑर्डर कंप्लाई करने का.
kindly say the last order matter. Para 7 matter.
Learned counsel for the review petitioner is directed to make the lead petitioner of such and such as also party in the present proceedings.
Yes, ma'am.
तो आपने पार्टी बनाया कि नहीं बनाया?
जो एक का बना चुके हैं, एक का बना रहा है, एक का बना चुके हैं, एक का ऑलरेडी पार्टी बना हुआ था.
वो तो पहले से बना हुआ है.
Yes,
तो आपने इस ऑर्डर का कंप्लायंस नहीं किया है ना? ठीक.
But in course of the
Contempt case civil number 534 of 2023 with civil review number 51 of 2023. Counsel for the petitioner of civil review number 51 of 2023 prays for and is allowed time till Wednesday to comply with the order dated 21/3/2025, failing which the civil review number 51 of 2023 shall stand dismissed without reference to it. ठीक है? If this order is complied, post civil review petition along with contempt case civil number 534 of 2023 on 13th of June. And in case the civil review petition is dismissed on account of non-compliance of this order, only the contempt petition will be listed.
Item 31, contempt till 546 of 2023.
वो जो आपका LPA डिसमिस हुआ था उसका SLP किया. डिसमिसल का ऑर्डर कहाँ है? LPA
और दो केस था.
LPA जो डिसमिस हुआ वो ऑर्डर कहाँ है?
वो हम लगा देंगे. एक दो केस था. एक केस पहले डिसमिस हो चुका था राउंड ऑफ लिमिटेशन एज वेल एज मेरिट. So it was listed. We showed that order because already that order, and in that case SLP has been filed. First case which was dismissed.
Merit.
So therefore they are saying that we will also move to the decision. We'll bring it on the order.
My lordship, the opposite party has trespassed their litigation, the jurisdiction. The period which has been decided by this court and the order have been passed 2004 to 2006. And in the light of the judgment, they have rejected my earlier claim which has been decided in the pension benefits. 1065 days. Those relates with the year 2007, 8, 11, 12. That has been decided by the earlier secretary. Now this secretary has cancelled all the entire leave. Those has cancelled. So that is not the limit of this contempt petition. And they have issued the same. And that has been filed by.
I pray that the operative portion of the order maybe I may be permitted to read the order and we have complied the order.
हर बात तो कोई और काउंसिल एप्लीकेट कर. आपको क्या ही पता होगा कि पहले क्या हुआ. नहीं पता है ना. पहले इसमें क्या क्या हुआ तो वो कहाँ है वो काउंसिल? कौन है?
मिस्टर सुरेश कुमार है.
कहाँ बता. अब आप क्या किए हैं?
लास्ट डिफिट है उसमें हम लोग हमसे अब एक मिस्टेक हुआ था कि कह दिए थे कि पूरा पेमेंट हो चुका है, बट दैट वाज ड्यू टू दी पे स्लिप हैज बीन इशूड बाय द फाइनेंस डिपार्टमेंट. उसके अनुसार सारा हो गया था, इनका टोटल हो गया था. मुझे लास्ट डे मैनेजर हैड राइटली पॉइंटेड आउट कि एचआरए और मेडिकल अलाउंसेस हुआ है कि तो वो अब हो गया है. नाउ देयर इज नो एनी ड्यूज अगेंस्ट दिस पिटीशन, नथिंग. और हम लोग स्टेटमेंट भी दे दिए हैं जैसा माय लॉर्ड ने बोला.
Not even a single leave has been adjusted.
No, Yes.
Para 9.
Para 9 में we have stated last जो affidavit page 8 para 9 that from perusal of the latest salary statement. Para 8 of the
पेज 8 पैरा 9 में तो कुछ नहीं है इसमें वो लेटेस्ट
Affidavit dated last affidavit, fourth affidavit, third affidavit.
Third April को हुआ है affidavit.
थर्ड एट बताइए पेज नंबर
Page number 8. Para 9. Perusal of the latest salary statement is further transferred that no deduction, adjustment has been made and full pay has been approved and paid to be paid in favor of the petitioner. जो लास्ट टू जो इनका जो बाकी था वो मेडिकल अलाउंसेस
नो डिडक्शन और एडजस्टमेंट मेडिकल अलाउंस और एचआरए का एडजस्टमेंट हुआ है नहीं हुआ है
नहीं
वो चार्ट से दिखता भी है, जो चार्ट हम लोग एनेक्स किए हैं उससे पता भी चल रहा है।
आपने तो पहले भी एक चार्ट लगाया था
हाँ नहीं उसमें थोड़ा हमको कंफ्यूजन था हालांकि इनको
तो ये 00 जो लिखा हुआ था ये क्या लिखा हुआ था 0 अभी एक नया चार्ट लगा दिया है ये पुराना ही चार्ट फिर से लगा दिया
नहीं ये नया चार्ट बना है सेक्रेटरी के ऑर्डर के अनुसार नया चार्ट जो बना है उसके अनुसार रिवाइज हुआ है।
तो माय लॉर्ड सिर्फ इसी चार्ट के एनेक्सर में लिखा हुआ है कि दिस कोर्ट ने इशू किया है लेटर सच लेटर हैज नेवर इशूड ऑर्डर कैन बी पास्ड बट लिखा हुआ है माननीय उच्च न्यायालय रांची का ज्ञापन 4301 दिनांक 28/3/2025
That was the letter issued by our office. That was by mistake.
प्लीज काइंडली सी एज जो
भाई यहाँ पर रेस्पोंडेंट के एडवोकेट को ही अथॉरिटीज लोग हाई कोर्ट मांगते हैं
यस
ऐसा ही सिस्टम है अपने हाई कोर्ट ऐसे लेटर किसी को
ज्ञापन जो है ना दैट इज आवर
कोई बात नहीं इट डजंट मेक एनी डिफरेंस
वो हम लोग भी मतलब वर्क आउट किए थे गलत
पुराना वाला तो रिवाइज कर दिए हैं चार्ट में
हाँ
एचआरए वगैरह सब दे दिए
सब देती है
उसके अलावा जितना पेमेंट सब कर दिए
सब करती है
पिछले ऑर्डर के बाद से लेके अब तक का जो ऑर्डर अब तक का जो भी उसके बाद भी कुछ पेमेंट किए होंगे
हाँ अभी इनको 54,000 रुपया हम लोग कह रहे हैं कि 2 सप्ताह में हो जाएगा तो हो गया है ओरली देयर से इस एफिडेविट
इनको पेमेंट हो चुका है
हाँ अगर
ये 54,927 इनको पेमेंट हो चुका है
ये हम लोग कहे थे कि 2 सप्ताह में हो जाएगा तो उस समय बना था पूरा
ये तक 3-4 का है
टू थिंग्स आर
तो आपको ये क्रेडिट हुआ है कि नहीं
टू थिंग्स
आपको ये
यस क्रेडिट यस आई गॉट एंड आई रिसीव्ड
ठीक है
एंड फर्स्ट थिंग माय लॉर्डशिप
now there is nothing
if the salary has paid to me annual increment must to be paid if the regularized the period has been regularized annual increment must to be given they have not decided the annual increment secondly the punishment inflicted that has not been decided this is the violation of the honorable supreme court order that is clear if the leave has been decided the punishment has to be condoned Honorable Supreme Court has passed this judgment and I have the judgment copy, my lordship, and I may supplement this copy, my lordship.
So this is contempt. As per the my lord's order.
कौन सा जजमेंट है आपका?
Yes, my lordship. Just I am showing. Unauthorized absence is an act of indiscipline. You may please. My lordship, kindly see the second stanza. Stanza 8. Unauthorized absence is an act of indiscipline. Whenever there is an unauthorized absence by an employee, two courses are open to the employer. The first is condone the unauthorized absence by accepting the explanation and censoring leave for the period of the unauthorized absence, in which event the misconduct is to condone. The second is to treat unauthorized absence as a misconduct, hold an inquiry and impose a punishment for the misconduct. So the period has been decided, the payment has been given, then why the punishment has been inflicted? That has to be condoned as per the guidelines under the order passed by the Honorable Supreme Court. And they are, the opposite party is under violation of the Supreme Court, Honorable Supreme Court order. So they must has to be passed the order by which the punishment inflicted that has to be condoned, and second the annual increments has to be given, and secondly another supplementary affidavit that has been filed, my lordship, they have decided earlier 1065 days. They have cancelled. Some earlier secretary has sanctioned the leave and they have rejected the claim in saying that this court has passed their judgment. Why this court has passed this judgment? Never this court has passed.
Where have they cancelled your leave?
Yes.
Leave cancellation कहाँ है?
वो अनेक्सर के my lordship kindly see अनेक्सर के कार्यालय आदेश संख्या 36/13/324 को रद्द किया जाता है और दिया गया है कि 29/10/2010 में ये ऑर्डर पास हुआ है. ऐसा ऑर्डर कभी पास नहीं हुआ इस कोर्ट के द्वारा.
Contempt case civil number 547 of 2023. The counsel for the petitioner is present in person. The learned counsel for the state is present. They have submitted that the calculation has been revised and as per supplementary show cause dated 3/4/2025, the amount payable comes to rupees 54,927. Counsel for the petitioner in person has confirmed receipt of the amount of rupees 54,927. However, the petitioner in person has submitted that annual increment has not been given and the opposite party has not acted in terms of the judgment passed by the Honorable Supreme Court in State of Punjab versus PL Singla, AIR reported in AIR 2009 SC 1149 and the unauthorized absence was required to be condoned. The learned counsel has also submitted that certain adverse order has been passed against the petitioner relating to other period.
Yes. Related with the 2011, 12 and something like that. Total 106 that is not related
Relating to other period, though that period is not relating to the present case.
And that is annexed K. In the supplementary affidavit, rejoinder affidavit 9/4/2025.
Considering the aforesaid submissions and the nature of the order passed by this court is not inclined to proceed any further in this contempt proceedings. If the petitioner has any surviving demands, it will be open to the petitioner to take steps as may be permissible.
Item 32, Contempt Suit 612 of 2023.
LPA has dismissed lordship, so sometime we will be given to take instruction.
Instruction in compliance. कब हुआ dismiss?
7th March 2025.
तो काफी हो गया टाइम. अब तक क्यों नॉन कंप्लायंस हुआ? 7th मार्च को आपका LPA डिसमिस हुआ.
Ground of limitation also that we was
So what?
Page 15 and page 18 are my lord's direction. They just had to pass a reasoned order on my claim for leave encashment and on my claim for GPF. Page 15, para 8.
They have not passed any
They have
order.
not passed any orders. Initially, they filed a show cause saying
Who was the person responsible for this?
OP number 3 and OP number 2. Director, GPF and secretary and investment.
OP number 2.
Lordship, simply praying for compliance. Lordship. We have communicated. I think we have found the order. Lordship. So one chance may be given Lordship because LPA has been dismissed.
Are you representing opposite party number 2 and 3? Or
Two Lordship.
what about 3? What about 3? बताइए.
As per the address section, certainly 2 and 3 both lots in.
Just a moment. Contempt case civil number 612 of 2023.
One chance.
It has been submitted by the learned counsel for the petitioner that LPA number 676 of 2023 arising out of WPS number 7486 of 2013 has been dismissed by judgment dated 7/3/2025. Still, the order passed by this court has not been complied. The learned counsel for the state has submitted that a compliance report will be filed in this case. Correct or not?
I am only paying for instruction, but sir, it is certainly.
He has no instructions in the matter. Let notice be issued to opposite party number 2 and 3 as to why a contempt proceedings be not initiated against them for non-compliance, for deliberate and willful non-compliance of order dated 15/12/2022 passed in WPS number 7486 of 2013 in spite of that should be sufficient. Through the concerned police station, for which requisites be filed by the petitioner within a period of 1 week from today.
May I submit one thing?
Post this case on 13th of June.
May I submit one opportunity में
कोई अपॉर्चुनिटी का कोई
Appeal
बात
has been
नहीं.
dismissed
आपको कुछ पता ही नहीं है.
नहीं,
आपको
नहीं.
कोई इंस्ट्रक्शन नहीं है.
No, no,
अपील 1 महीना से ऊपर हो गया डिसमिस हुए.
We have
आपके
been-
पास कोई इंस्ट्रक्शन नहीं है.
है,
लेट द
है.
नोटिस को नहीं है. आपका काउंसिल नहीं बना.
नहीं, एक बात सुन, हम जस्ट वही फोन करके ही आ रहे हैं. They are exploring the whether
कोई बात नहीं.
खाली एक चार्ज दिया हुआ हम
इससे
comply
क्या
करा.
इससे क्या
Subject to
भाई
decision of-
नोटिस ही किए हैं. किए ही क्या
हम मान लिए,
It will
हम-
be open to the opposite party to file a compliance report.
हाँ yes.
Item 33, contempt to double 6 of
नहीं नोटिस तो जाएगा.
हो गया तो कम से कम compliance report तो हम फाइल करेंगे तो उससे बचेगा ना. If I am complying, that's what I'm saying. Because unless we one chance would have been given, but we would have complied with it.
देखिए एलपीए तक हम लोग वेट करते हैं. ठीक है. आप 2-2, 3-3 साल लगाते हैं तो भी वेट करते हैं. लेकिन जब आप एलपीए डिसमिसल होने के बाद जब आप लोग ये सब करते हैं ना तो हम लोग को समझ नहीं आता.
फाइल जो है भेजा गया लॉ
वो
डिपार्टमेंट.
फाइल आपका चलते रहेगा.
नहीं.
आपका तो 90% एलपीए लिमिटेशन पे डिसमिस होता है.
केवल एक चार्ज.
90% ऑफ योर एलपीए आर डिसमिस्ड ऑन लिमिटेशन.
ये भी उसी पर.
ठीक है. ये भी
एक चार्ज दे दिया था
लिमिटेशन.
बस यही कहा.
यू आर एब्सोल्युटली नेग्लिजेंट. आप लोग का यू आर नॉट मेंडिंग योर बेस कि भाई क्या ऐसा करे कि आप लोग जानबूझ के करते हैं कि लिमिटेशन पे डिसमिस. आप एक बात बताइए, सेम कोर्ट में आपको एलपीए फाइल करने के लिए लिमिटेशन कैसे लग जाता है?
सब इंप्रूव हो रहा है. खाली एक
कुछ नहीं
बात
improve हो रहा.
एक चार्ज दिया है मैडम. बिकॉज़ मेरा आप सुन ले, हम लोग फोन से बात करके आ रहे हैं
कुछ आप फोन पे बात करते रहिए.
एक बार सुन लिया जाए.
हम सुनिए.
नहीं, हम ये बोल रहे हैं कि
यहाँ पे केस के ऑर्डर को नहीं कंप्लाई करने के लिए जब यहाँ से हम लोग बोलते हैं कि कंप्लायंस रिपोर्ट फाइल करिए तो आपको दिमाग में आता है कि एलपीए फाइल करिए. और जब आप एलपीए फाइल करते हैं तब तक काफ़ी समय बीत चुका होता है. एलपीए हो जाता है टाइम बाद. जितना पैसा उसको नहीं देना है उससे ज़्यादा आप लिटिगेशन में खर्चा कर देते हैं.
सब बात सही है मैडम. खाली एक चार्ज दिया है, हम बार-बार बोल रहे हैं.
अभी तो सुप्रीम कोर्ट का ऑर्डर भी आ गया है कि अगर टाइम बार्ड केसेस हैं तो रिस्पॉन्सिबिलिटी शुड बी फिक्स्ड.
यस.
तो व्हाई शुड इट नॉट बी फिक्स्ड ऑन द काउंसिल्स?
हाँ यस मैडम. अगर हमारी जिम्मेदारी हो तो होनी चाहिए.
तो फिर
लेकिन एक बार इसमें एक बार मेरा बात सुन लिया जाए. हम लोग ऑलरेडी खबर किया, हम इंस्ट्रक्शन लेके
अच्छा केस का आप ऐसे ही कर देते हैं टाइम बार्ड और उसके बाद एक ऑर्डर हो जाता है, फिर हम लोग को उस ऑर्डर को फिर फॉलो करना पड़ता है सारे
हम
केसेस।
लोग एक इंस्ट्रक्शन लिए हैं मैडम, मेरा बात सुन लिया एक बार, either they will do something or comply with the order,
Yeah,
नहीं तो
do
otherwise next day को सेम ऑर्डर कर दिया जाएगा मैडम।
नहीं, सेम ऑर्डर नहीं होगा, पुलिस स्टेशन से जाएगा ना जब सर्विस करने,
बार
तो
सुन
बहुत बहुत ठीक लगता है
हम
हमको
instruction
कि जब
लेते
जब सेक्रेटरी के पास ऑफिसर इंचार्ज पुलिस स्टेशन जाके बोलता है कि यहाँ साइन कर दीजिए।
I have
I
received
like
the
it.
instruction, my lords.
Because they have- they don't have
File has
any-
been sent to law department for exploring
आप
orders.
अपना करते रहिए लॉ डिपार्टमेंट।
खाली एक बार कर
चलिए
दिया है
ठीक
my lords।
है। अब ये कौन सा मैटर है?
Item 33.
एक बार खाली ओवर
नहीं हो गया ना, क्या है, नोटिस जा रहा है। भाई नोटिस जा रहा है, नहीं
खाली एक बार और दे दिया
नहीं,
था,
नहीं
हम लोग कंप्लायंस करा देंगे
नहीं
मैडम।
करेंगे।
हम
2022 का ऑर्डर 2025 तक
एक बार
compliance
मैडम करा दिया, अभी तक एलपीए पेंडिंग था, 7 मार्च को
वही ना।
हम
एलपीए कब फाइल करते हैं? जब यहाँ कंटेंट में आप लोग से पूछताछ करते हैं तब आप लोग एलपीए फाइल करते हैं, उसको 6 महीना तक डिफेक्टिव रखते हैं, उसके बाद 2 साल बाद वो डीएफ वो हो जाता है नॉन मतलब फॉर लिमिटेशन।
जनरल बात है मैडम, इसका इसी में एग्जांपल नहीं बनाया जाए, एक बार चाप दिया जाए, मेरा प्रेयर है
कुछ नहीं होगा,
एक बार चाप दिया जाए ना, हम नहीं होगा तो
हम चांस तो दे रहे हैं आपको, आपको तो बोल रहे हैं, इनको नोटिस सिर्फ जा रहा है।
खाली एक बार चांस दिया जाए, नहीं होगा तो किया जाएगा, हम
चलिए
नहीं
बताइए,
बोलेंगे।
who is appearing in this case? 669 of 23.
The state has preferred an LPA relief after a delay of more than 700 years. 700 days, my apologies. And till date, it is lying effectively. It has not been registered.
तो रोज हर एक केस का यही कहानी है, आप लोग का हर एक केस का यही कहानी है। This is not an isolated case. It has become the policy of the state to file delayed LPA. It is your policy. क्योंकि जिस आदमी को आप आज डिनाई कर रहे हैं रिलीफ, वही रिलीफ आपको कल चाहिए, तो कैसे मिलेगा? ऐसे ही मिलेगा, करेक्ट? यही है ना कहानी। ये कुछ ज्यादा बोल दिया,
गलत तो है,
यही कहानी। आज एक रिटायर्ड आदमी को आप ये बेनिफिट कोर्ट से मिला, आप जान रहे हैं ये बेनिफिट हमको कल अवेल करना है क्योंकि हम भी रिटायर करेंगे, तो रहने तो एलपीए 700 क्या 7000 दिन बाद फाइल करें। यही तो है, केस मेरिट में कहाँ डिसाइड कर पाते हैं बताइए? कभी कोर्ट को बोलते हैं कि इसमें एक पॉलिसी मैटर है, इसको डिले कर दो, कुछ नहीं, कोई मतलब ही नहीं है। It's a policy of the state to file delayed LPA. डेली बेसिस में किलो के भाव में आपका एलपीए डिले पे डिसमिस होता है ना? What steps have you taken to improve this? जो आदमी केस कंडक्ट किया उसको नहीं पता है कि मेरा केस में क्या चीज है, हमको किस पॉइंट पे एलपीए करना है, क्या करना है। इंट्रा कोर्ट अपील में ऐसे डिले 700 दिन का नहीं हो सकता। बताइए इसमें क्या चीज है?
As per the advertisement, the pay scale had to be fixed and the monetary benefits had to be paid.
Page 20, this is for the content.
Operative portion is at page 26.
ये वही एडवर्टाइजमेंट में जो पे स्केल
जी जी जी,
इससे ज्यादा दुर्भाग्य क्या हो सकता है? एडवर्टाइजमेंट में एक पे स्केल एडवर्टाइज करिए, उसके बाद बोलिए नहीं, यू आर नॉट एंटाइटल्ड टू दिस पे स्केल। कोई प्राइवेट पार्टी करे तो फ्रॉड बोल देंगे उसको, सरकार को तो नहीं बोल पाएंगे। तो प्राइवेट पार्टी अगर एडवर्टाइजमेंट निकाले, बोले कि 10,000 रुपये सैलरी है और दे 5,000 रुपये, फ्रॉड का केस में कन्विक्शन हो जाएगा उसका। करेंगे ना आप? फिर एलपीए 700 डेज का इस तरह से तुरंत करना चाहिए ना। चलिए ठीक है, क्या करेंगे? एलपीए का क्या सीरियल नंबर पड़ा है, क्या पड़ा है?
फाइलिंग नंबर
कब फाइल की?
27 Jan 2025.
27 January 25।
There was an order of the notice code of 24th January asking for a show cause. Thereafter, the LPA. IU number 3384 of 2025. Who has filed this IE?
Assistant Director.
Is it permissible under law?
No.
Then content matter में individual notice भेजे हैं by also indicating that he may engage an independent counsel. How anybody else will file an interlocutory application? बताइए आप कैसे फाइल कर दिए इसको बिना वकालतनामा के बिना किसी बात के ये कोई स्टेट का एफिडेविट है क्या फाइल करिए मंडे को फाइल करिए देखिए आइए नंबर 3384 of 25 has been filed with a prayer to defer the hearing of the present contempt application. However, the IA has not been filed by the alleged contender, opposite party number 2. Although by the order dated 24/1/2025, when notice was issued to opposite party number 2, it was observed that it would be open to the opposite party number 2 to engage an independent counsel to pursue this case before this court. But no independent counsel has been engaged by opposite party number 2, and IA has been filed by another person who is not connected with this case. Accordingly, IA is not accepted, which is hereby rejected. Counsel for the state. Submits that the matter be posted on next Friday. Here, however, he has submitted that the LPA filed against the writ order, which is barred by limitation by how many days? आप बताइए.
Almost 700 days. More than 700.
More than 700 days is still defective. तो कुछ तो आपको करना ही पड़ेगा. आपने बोला कि you will remove all the defects, make all endeavor for early hearing of the appeal. 6th February 25. This was ordered wrong. Friday को एक बढ़िया सा ऑर्डर we will initiate. We will certainly initiate a contempt proceedings. आपके अंडरटेकिंग का आपको कोई वैल्यू नहीं है और आपके लिटिगेट होते कोई मतलब ही नहीं है. The records of the case shows that the opposite party number 2 has no regards for the orders passed by this court and has taken the matter very casually. As back as on 6th of February 2025, the counsel for the opposite party had submitted before this court that all endeavour will be made to remove the defects in the LPA and appropriate steps will also be taken for early hearing of the appeal. And the matter was directed to be posted up to 4 weeks. In spite of such submission, the appeal continues to be defective. Therefore, this court is of the considered view that pendency of a defective appeal and in spite of giving undertaking before this court that all endeavour will be made to remove the defects and pursue the appeal, no steps are being taken. The same cannot be a reason for non-compliance of the orders passed by this court. Next Friday, तैयार हो गया है, ठीक है? We will draw a proper order. SLP के लायक आपका केस बन जाए. आप जाइए SLP में जाइए.
गलत तो हर लेवल पे गलत है.
ये नहीं चलेगा.
हर लेवल पे गलत है क्या होगी?
ये ना मौखी. अरे भाई जाइए ना अपील पे, कौन आपको मना करता है? मेरिट पे डिसाइड कराइए. डिफेक्टिव पिटीशन फाइल कर करके लिमिटेशन पर अपने सारे SLP डिसमिस करा के किसको सर्व कर रहे हैं आप? Whom are you serving? भाई my orders may be wrong. I'm happy if it is set aside. Wrong orders are required to be set aside. उसको भी आप लिमिटेशन में डिसमिस करा देते हैं, फिर सुप्रीम कोर्ट जाते हैं. 1 लाख रुपए पेमेंट करने के लिए का उसका कॉन्सिक्वेंस 1 लाख रुपए से ज्यादा का नहीं है, लेकिन 4 लाख रुपए खर्चा कर उसके पीछे डिफेक्टिव और लिमिटेशन टाइम बार्ड केसेस फाइल कर रहे हैं. एब्सोल्युटली डिस्गस्टिंग. कितना केसेस आपका साल में डिसमिस होता है? कभी कुछ का कुछ फिगर है आपके पास? लिमिटेशन पे कितना केसेस आपका LPA डिसमिस होता है साल में?
इस मंथ में तो 4 हो चुका है. ये मेरा पर्सनल नॉलेज है.
Yesterday's list.
Lordship had ordered for substitution and to carry out necessary amendment, but we inadvertently did not do so. Lordship, we really granted permission to do it.
Inadvertently, क्या चीज़ का
Yesterday at serial number 7 there was a substitution petition which was allowed by the Lordship, and we were directed to make necessary corrections in the allowance cost item, but we could not do so. Lordship.
वो आपने इसलिए नहीं किया क्योंकि 4:30 बज गए होंगे, घर जाना होगा. हम लोग को पता है कैसे कैसे दिमाग काम करता है. कोई बात नहीं, हम उस ऑर्डर को एक्सटेंड तो नहीं कर सकते.
Lordship permission.